Lord, in this matter, Lord, inadvertently, Lord, a wrong submission made on my behalf, Lord. Out of that, Lord, the matter was out of the. Your Lord was
Give the number. Give the number. Huh.
May it please, Milord.
Yes.
Let us seek your lordship to appear virtually, Milord. Milord, this is a matter your lordship would recall. Just 2 days back, your lordship was pleased to transfer one suit from Siliguri to Calcutta.
Oh, a correction is required, right?
Yes, Milord. Yes, Milord. Inadvertently, the wrong suit number has been. But Milord, kindly come to page number 3.
Yes.
The second paragraph, on the prayer of the petitioner, liberty is granted to the petitioner to seek transfer of case being 517 of 2023 to the same court or before the landed district and sessions at 24 Pargana South. That is my suit. So it would be the matrimonial suit number 123 of 2023 before ADJ's second court at Shialda.
I do not follow. Please repeat.
My lord, in the second paragraph, your lordship has given me the liberty to seek transfer of a particular case before the landed district and sessions at Shialda at Alipur. My lord, this is my suit which I'm already contesting at Shialda.
So what should be the number?
It should be MAT suit number 123 of 2023, Milord. And the liberty that I sought was to seek the transfer of that suit, Milord, to the ADJ second court at Shialda. But I'll tell your lordship the practical difficulty. But I've taken instruction, Milord. That day, your lordship had asked me a very pertinent question as to why I was seeking transfer before the district and sessions judge at Alipur, Milord. Milord, the Shialda court is the subdivisional court of North South 24.
MAT suit 121 will be transferred from Siliguri to Alipur, right?
Yes, right. Yes, Milord. Yes.
And you want this 121 to be heard with
517 of, yes. So, my lord, additionally, I sought a liberty to seek transfer of 123 of 2023 to Shialda, my lord.
121, isn't it?
120, yes, 123 of
121.
Yes, yes. My lord, not 120, yes, 121 of 2023, my lord. And before the second court at Shialda, it is the second court at Shialda.
No, you have to apply before the district judge for a transfer. That
right.
has been granted. So only I'll change the number. I'll correct the number of the MAT suit.
But my lord, that would then create a problem. That suit will anyway be transferred to the ADJ at Alipur, my lord. District and sessions at Alipur by your lordship's order. So, my lord, I sought the liberty. Your lordship has given the direction for that suit to be transferred to Alipur, my lord. Additionally, your lordship, I sought a liberty, my lord, to seek transfer from the ADJ to Shialda, my lord.
I have granted, I have allowed transfer to the district and sessions judge.
Right, absolutely, my lord. Now, additionally, my lord, I sought the liberty to seek transfer of the.
He may deal with the matter himself or transfer it to the bench, right?
Right.
So your application will also be made before the district judge, seeking transfer before the same court. Not before the additional district judge, before the district judge. There no correction is necessary.
My lord, then my lord, kindly correct the case.
I'll correct the number. Yes.
I'm grateful.
Inadvertent error has crept the order passed on 22nd April 2024. Stop in the second paragraph of the third page of the order, comma. 517 of 2023 be read as 121 of 2023. Right?
My lord, may I additionally point out another thing, my lord. The paragraph reads, transfer of case being so and so to the same court before the district and session judge, not 24 Pargana.
The application to be made before the district judge for transfer to the same court. There's a comma there in between.
Okay, because the server copy, there's no comma, my lord. That is why I'm getting confused.
The department is directed to incorporate necessary correction accordingly. Paragraph, this order be treated as part of the order passed on 22nd April 2024, urgent certified website.
I'm extremely grateful. Your Lord.
Next,
I'm appealing for the petition.
Petition number 2. I'm for the state. I am for the opposite party number 2, my lord.
yes,
In this matter, there is a direction upon the opposite party to file opposition.
My lord,
you are seeking extension of interim?
yes, my lord, interim order. If your lordship-
22nd of April, Lordship.
If your lordship kindly sees the order dated 9th of April 2024, my lord, the interim order was till the first date of the available circuit. That is,
22nd of that.
therefore, my lord, the interim order is expired.
22nd,
You have
the
already filed
application
that,
was filed on
Yeah.
18th,
Okay.
No
prior
copy-
to expiry.
No copy has been served.
Yeah.
Did not serve copy?
Absolutely. No copy, no notice of mentioning nothing, my lord.
How are you?
You have not mentioned.
My lord, we saw it in the list.
I have already given the evidence, sir.
My advocate on record is here. It might be that they have served it, sent it to the,
Where is the service? Dispatch to beat office? Should check yourself, sir.
and my lord,
I'm
kindly appreciate
handing over.
when the advocate is appearing, my lord, it has been deliberately sent to the litigant.
No, litigant will
You have
inform
not
you.
complied with
But
the
that
order.
That is also
You have not-
fine,
no,
but
there
then it
was-
is not served.
We have served the state, Lordship. State is also the party, Lordship.
The private respondent
Yes,
is not a party.
He is also the party.
Then
We
you
have
to serve
said,
both.
but if it is
You
not,
have in fact sent it to the private opposite party, but it's not served.
But practice is, my lord knows that when the
it
advocates are
be-
there, it would be.
Yes, it
Interim
will be
order will be
extended for a
extended,
limited period.
No, my lord, what my humble prayer is that it is ready for hearing. So if
Yes.
your lordship can kindly takes it up on Tuesday or Thursday as per your lordship's convenience, my lord, we'll hear this matter.
yes, we are also ready to.
Affidavits are exchanged.
No, my lord, revisional application, my lord, affidavits are. We
There's
will
a
not-
direction for affidavit.
No, that was in respect of CRAN.
That was
3.
your, yes, can 3,
So
yes.
it was my prayer in what had happened, my lord, the interim order asked earlier was vacated by the honorable court. So the petitioner had filed CRAN 3, praying for fresh interim order, where my prayer was that I would like to file an affidavit in respect of CRAN 3. But the honorable court, my lord, was pleased to extend the interim order. So in all respect, my lord, CRAN 3 has become.
Have interruptions, right? So let me fix the CRR
Yes,
for hearing
as your
next week.
Yes.
Any day.
Lordship, I am holding the CD.
And let the interim order be extended for limited period.
Yes, please take back your affidavit, sir. This is not service at all. Okay. A CRAN 4 of 2024.
If your lordship would kindly excuse me, my lord,
Yes, yes, sure, yes.
my advocate on record is.
This is an application for extension of the interim order, which was granted on. When was the interim order granted? 11th May 2023,
Lordship.
granted on 11th May 2023. Paragraph, adjournment counsels for the parties. Paragraph, the interim order granted earlier is extended till 31st May 2024 or until further orders, comma, whichever is earlier. Grant such and such is disposed of. CRRA, let the matter appear under the heading criminal revision on 30th April. Next.
Item number 3, I beg to appear on behalf of the petitioner. Your Lordship.
You are appearing for?
Extension of interim
This is
order.
extension of interim order.
Your Lordship, this is the
For the limited period.
Your Lordship,
Yes.
this, on October 4th, 2023, there was a direction to file an affidavit in reply by the petitioners on, by 29th November 2023. They haven't
you
filed it
filed?
yet.
No, Your Lordship, I would comply with that order. Your Lordship, kindly.
Within 7 days.
Lordship. Lordship.
When was the interim order granted?
It was first granted by Honorable Justice Ghosh on 30th June 2023, Your Lordship, and subsequently it was extended by Honorable Justice Ghosh again on 4th of October, Your Lordship, and subsequently by Justice Abhijit Gangopadhyay on 15th of December 2023, Your Lordship.
The GR case has been stayed by way of an interim order, right?
Lordship. Lordship.
Affidavit of service. CRAN 3 of 2024, huh? This is an application for extension of the interim order. Granted video order passed on 30th June 2023. Granted video order passed. A paragraph for learned counsels for the parties. Paragraph, the interim order be extended till 31st May 2024 or until further orders, comma, whichever is earlier. CRAN such and such is disposed of. CRRA order given.
Direction may be given.
I will, yes, CRRA order given. Learned counsel for the petitioners seeks extension of time to use the affidavit in reply as sought. Paragraph, affidavit in reply be filed within a week from date.
Lordship.
Paragraph, the matter be placed before the next available circuit bench.
Lordship.
Next. Interim যেটা হ্যাঁ ডেটটাও বলেছি আমি শুধু এই ভিডিও অর্ডার পাসড অন
Time for the petitioner, my lord. There's a extension of interim order, my lord. The earlier order was passed on, my lord, 23rd of November 2023. There was a stay for 12 weeks, my lord.
So it has expired.
Expired, already expired. Lord, Lord, let the revisional application be heard, my lord. Can the date may be fixed, my lord, next week, my lord.
Very good.
Any convenient,
12 weeks is over long back.
long back, my lord, in the month of February, my lord.
Yes, so we are in April now.
You are
So
April,
let me fix
already
a date for hearing of the revisional application.
Lordship.
The CD is required.
Yes, ma'am, it is required.
Please produce the CD on the next date. CRR along with Canada. Cranford, very good. CRR is okay. Both the parties are represented. Is there any private opposite party? Yes, have you served? Yes, have you served? You serve and come back. The petitioners and the state are represented. Paragraph, service upon the private opposite party is yet to be completed. Paragraph, let the matter appear under the heading criminal revision on 2nd May. Next Thursday, 2nd May. 2nd May. Paragraph, affidavit of service be filed on the adjourned date. Next. Yes, the contemners.
My lord, I am for the alleged contender, my lord. Later, Mr. Chondishwar on the years.
Yes.
My lord, I am appearing on behalf of the contender, my lord. Later,
Yes,
Mr.
yes.
Chondishwar on the years.
Yes, yes. Have you served? Have you received a copy of the exception?
No, my lord. Till now, not my lord.
Where is the service? Please show me. The affidavit of service. The track report. You have to show service. Track report ta kothay? Eta to you have posted, you have sent. It has to be served, isn't it? ট্র্যাক রিপোর্ট ছাড়া আমি কি করে বুঝবো উনি পাননি বলছেন? ট্র্যাক রিপোর্টটা না দেখলে আমি তো বুঝতে পারবো না যে আপনি ডেলিভার্ড হয়েছে। ডেলিভার্ড হতে হবে তো। You have not received the copy here. She has sent by post
No, my lord, not yet been.
and by mail also. কোন মেলে পাঠিয়েছেন? Oh, at your mail ID. Please find out, Mr. Sarkar. Let the matter appear next week. Please find out in the meantime.
Grateful, yes.
She has mailed
I'll
it
check
to you. Additionally, she has sent it by speed, by post.
Okay, your lordship.
And she
I'll check
says
it.
it is your mail ID. Right? She says it's Mr. Anirban Sarkar's mail ID. So please
Yes, my
find
lord,
out and
I'll check it.
please find out and get ready. Next Monday, Ashu. I'll fix it next Monday. Right?
Yes, yes. Grateful, yes.
Affidavit of exception. Affidavits, huh, দুটো আছে, of exception submitted on behalf of the applicant petitioner is taken on record, are taken on record. Paragraph, since service of the affidavits is not complete, comma, let the matter stand over till 29th April 2024. Track report টা আনবেন পরে। Next.
I'm grateful, your lordship.
What is wrong? Passed over. Pass. Your opinion?
I am the respondent.
Passed over.
I am the respondent.
I'm passing it over because.
Lordship,
Yes.
Lordship, this is item number 8. I am for the petitioner, Lordship.
Yes, yes. Filing.
Lordship, I seek one week accommodation. Let the matter be fixed on first. I want to be present before the Lordship physically. And I will be grateful if the matter is fixed on 1st of May.
He wants to come back on 1st of May. Is it all right for you?
Wednesday, my lord.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 1st May 2024.
Grateful, Lordship. Grateful.
Next.
My lord, item 9. My lord, I am for the petitioner before your lordship. My lord, may I permitted to my lord for next Wednesday for physically move the application because my lord.
How many matters will be fixed next week? 2nd May.
My lord.
Is service complete? Have you served?
My lord, I already, my lord, communicate to the, my lord, bank advocate, Mr. My lord, learned advocate Vikramaditya.
Where is
My lord,
the
I will,
affidavit
my lord, again, my lord.
affidavit of service?
My lord, I will next day, my lord, I will.
Please show me your affidavit of service.
My lord.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 2nd May 2024.
I'm grateful and much proud, my lord.
Next.
Lordship, I am appearing for the respondent.
Petitioner? Anyone for the petitioner? Passed over. Yes.
They have appeared around last edition, mediation has been paid.
That is recorded. The report is there.
Both of us are
Yes,
there.
we were present.
So the report has been said. So lordship, both were present, the mediation phase.
Mediation process failed. The report is there. You're asking for expeditious disposal? Let that be
Yes,
done.
yes.
What is the stage? Oh, only WS now. Issue has been framed. Which court? Alipurduar. Alipurduar. Please see your prayer A. Mahalbajar and Alipurduar typographical. Please do the necessary corrections. And the number is all right, 443 of 2021? Paragraph. On prayer of the petitioner, liberty is granted to.
No, Lordship. Number is also not correct, Lordship. The mat suit number is 349 of 2020.
But the order also records 443 of 2021.
But annexure P1 mat
6th March, there are two mats, so that's the confusion.
mat 349 of 2020.
Annexure P1.
Yes, Lordship. In my copy. What did
So this is dismissed for non-prosecution.
Mat
Annexure P1, that it's dismissed for non-prosecution. The other, maybe that's the other suit. Well, on prayer of the petitioner, liberty is granted to correct the name of the district in prayer small a of the application by incorporating Malbajar in place and stead of Alipurduar. Paragraph. Produce the report submitted by the learned mediator. It appears that mediation has failed. The innocuous prayer of the petitioner, paragraph 1, is for expeditious disposal of the matrimonial suit, being mat suit number 443 of 2021, pending before the learned additional district judge, comma, Malbajar, comma, district Jalpaiguri. Paragraph. Upon consideration of the submission on behalf of the parties, comma, this court is inclined to hold that expeditious disposal of the suit shall endure to the benefit of both the parties. Paragraph. In view of the same, comma, the application being CO 40 of 2024 is disposed of, is allowed, directing the learned additional district judge, comma, Malbajar, comma, district Jalpaiguri, to dispose of the mat suit being number 443 of 2021, pending before him as expeditiously as the business of the court would permit, comma, preferably within a period of 4 months from the next date of hearing fixed before the learned court. Urgency report. Next.
Lord, item number 12. Lord, am I?
Yes.
Fine.
12.
I'm appearing for the petitioner in this matter.
Yes.
Appearing for petitioner. The
my lord, we see that there was an interim
Yes,
order which is till 30th of April.
you're asking for
Now,
only
my lord,
extension.
the revision application. Now, my lord, we want to get the matter heard out. So, my lord, physically, there are some checks which needs to be brought to my lord's notice.
You are not clearly audible. Your voice is breaking.
My lord, we want to get the matter heard out before your lordship, my lord, kindly keeps it on Monday, my lord, so that we can travel physically and my lord place the matter because it has certain documents, volume in nature, my lord. My lord, will find us indicating,
is
my lord, all
appearing for the-
documents are also placed on the earlier. My lord, for the opposite parties, Mr. Saptanshu Basu, Mr.
Yes.
Parthapratim Rai appeared.
Yes, but
Now,
today
my
I
lord,
cannot find any of them appearing.
my lord, I shall inform Mr. Rai, my lord, he is in High Court.
You want to come back on Monday?
My lord, I wish to come back physically on Monday with this matter,
Well.
my lord. And my lord, only thing, my lord, the interim order is 30th of April, Monday is 29th. So, my lord, can it be till the Friday,
Come back on Monday.
till the
If
next
it
Friday?
is, come back on Monday, please. If it is not taken up, I'll extend it.
And my
Because
lord, only
extension till
one
Friday will
request.
not really help you. It has to be extended further.
Very,
There's no circuit in
very
the
well, my lord.
next week. So come back on Monday. If it is not taken up or disposed of, I'll extend it.
My lord, one indulgence, my lord. Can
Yes.
this matter be item number 1 so that we can do it and get back to Calcutta again? Because Tuesdays and Wednesdays, my lord, I have fixed other matters.
There is an interim order till disposal of the suit.
No, my lord, the High Court which passed the interim order by order dated 20th of March. You know, paragraph number 7. You got until April
Very well.
30th, 2024.
Let it be extended in that case till 31st May. There will be another circuit.
No, my lord, I would beseech, my lord, because
I'm
this order is
I'm
restraining me
fixing a
from
date.
selling.
Very well.
My lord, this order,
বিশু বাবু এটা একটু উপরের দিকে রাখবেন তো সোমবার কারণ আপনারা ব্যাক করবেন আবার none appears for the opposite parties. Paragraph on prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 29th April 2024, fairly at the top.
much obliged. Okay.
Next. 13? Yes. Who is appearing for the?
I'm appearing for the respondent.
There was a custody that is significant problem. In this case, then this case, our section 30 has been taken out in connection with the Matrimonial bill that has been separate registered. Wherein an interim order has been passed by the Calcutta in favor of the section, whereby the petitioner has been allowed to see the case once it becomes to the particular act. So when the order was executed, there was a petition of that's what I see. It's also modification application. That modification application was put on record and it was fixed for there. but that particular hearing has not yet been heard of. Because they switched in a particular date, subsequently, they are not, on that particular date, no hearing was there. But subsequently, there was no reference of hearing of the particular application. And the main should be going on as pending of issue. But no hearing of this particular modification application has been taken. Only paid to the aid for your loss. So that section of the part of the government to carry out my modification application, direct time bound. This is not 100,000.
Please show me the original order and the modification application.
First, order was passed.
Modification, the order was passed on 11th October.
This one is covered the question, not suitable. But it's but it was taken out on 17th of order, on 17th of October 2023. Categorically observed by the that the here for modification of the order dated 11th of October 2023, the here for modification is declared in the record. And 6th of December 2023 for hearing of the petition. Now, next order, there was no reference of hearing of any of that.
It will be disposed of within 1 month. Yes. Which court is this? Alipurduar must be having, it's supposed to be a heavy court. Let it be 1, not 2 weeks. Yes.
My lord, I do not have any objection if the thing is carried out within a month. But the thing is, in the petition, some material facts have not been disclosed. Prior to the filing.
In which petition?
In this petition. Prior to the filing of this application under Section 9, there have been various applications that have been, one being an application under Section 12 of the Protection of Women from Domestic Violence Act that is pending in the Judicial Magistrate Third Court at Jalpaiguri. That was filed long prior to this. There's a maintenance case under.
How are those relevant in this application?
I just would like to bring this on record, Your Honor, Your Lordship, because the fact remains in these cases have been filed more than a year ago. If there was record of these cases, they've been taking continuously time in, whereas these orders was passed ex parte without our presence in the court. We filed a WO and WS in this on the 15th of January 2024. And we have been regularly appearing on all the dates. However, in other cases, they have been showing utter disobedience, not filing the required declarations of assets and liabilities, anything. They have been continuously taking time on the last 3-4 occasions in each of the matters that are pending before the court at Jalpaiguri, Your Lordship.
That's not relevant in this.
That's not relevant.
So I'll only give a direction for hearing this application. That's all, nothing more. Right?
Yes.
You can move before the appropriate forum.
Yes, Lordship.
Even before this court for expeditious disposal of those matters.
Yes, Your Lordship.
এসিটা বাড়াতে বলতে গরম লাগছে তো, সব বন্ধ করে রেখে দিয়েছেন কি? এসি গুলো চলছে না? 20 গরম লাগছে। Aren't you all feeling hot? এসি গুলো ঠান্ডা করুন ঘরটাকে, ওগুলো সব কমান। এসি গুলো আছে কিন্তু কোনো ঠান্ডা নেই। The application will be of the application, yes. Let that be as it is. I'll give a direction for disposing of this application within 1 month from communication. That is your prayer. Preponement of the original matter is not subject matter of this application at all. The modification application is fixed on? No, that's why. That's why I'll give a direction to dispose of the application within 1 month. So let the judge fix a date and inform you. Heard learned counsels for the parties. Paragraph. The petitioner filed a matrimonial suit being number 335 of 2023, 335 of 2023, under section 9 of the Hindu Marriage Act 1955 against the opposite party, who is his wife, which is pending adjudication before the learned trial court. Stop. An application filed by the petitioner seeking visitation rights with regard to his minor daughter was allowed by the learned court by an order passed on 11th October 2023. Stop. The petitioner faced some difficulty in visiting the child, for which he filed an application seeking modification of the order dated 11th October 2023. Application when did you file the application?
17th of October.
Where is the date? Yes, file an application on 17th October 2023 for modification. Seeking modification, seeking modification. The said application is yet to be considered by the learned court. Stop. The innocuous prayer of the petitioner is for a direction upon the learned trial court for expeditious disposal of the application. Paragraph. Upon consideration of the submission made on behalf of the parties, this court is inclined to hold that since the application for modification filed by the petitioner on 17th October 2023 is still pending, though the suit is being proceeded with, the learned trial court being the learned additional district judge, Alipurduar, be directed to dispose of the application dated 17th October 2023 within 1 month from the date of communication of this order, in accordance with law. Disposed of urgency record website. Yes, from the date of communication 1 month. Next. Passed over. Passed over. Passed over.
Lordship, I am appearing on behalf of the respondent.
Next circuit. 17. On prayer of the petitioner, the matter be placed before the next available circuit bench.
Any.
Next.
Obliged, Lordship.
Yes, 18.
My lord, 18, 19, 20, 21. I am appearing on behalf of the petitioner, my lord.
Who is appearing?
I, Chitrabhanu Gupta, my lord.
Well, you are not visible. Yes. Who is appearing for the respondents?
I am for respondent number. My lord, I am for respondent number 1. My lord, in item number 18. My lord, I have filed the opposition.
Have you served?
I have served.
My lord, we have not yet received any affidavit in opposition, my lord.
You've not received, you've not served.
Yes, my lord, I have served.
How have you served?
I have served physically, my lord, to her junior, my lord.
So you have to use a, it is served upon your junior friend, sir. You seek to use a reply to it?
Yes, my lord, but if my lord then grants a time to allow me to give a reply to it, because I need to check, because I have not yet received the same, my lord.
I'll grant you 2 weeks.
Yes, my lord.
For the reply?
My lord.
Kindly grant only 1 week, my lord, because it is pending since long
Where
time.
is the service, sir?
My lord, I have
And when
served.
did you serve?
Well, kindly make it
It
short.
is a February order, 13th
Yes,
February
I
order.
have served, my lord, 29th of February. 29th of February and upon respondent number 9 to 11 on 3rd of March, my lord.
Very well, 1 week for reply.
My lord, there is an interim order, my lord. There is an interim order of stay. If my lord extends it for that time, my lord, because
Let it be extended for a limited period, right?
my lord.
Madam, আমি respondent number 15, ওনার ভারতীয় গ্রামীণ ভান্ডার, রুরাল গোডাউন। তো আমি এর আগে
আপনি
আসতে
কি
পারিনি।
নিজে মুভ করতে
আমি
চাইছেন?
নিজে মুভ করছি ম্যাডাম। আর মানে যে কয়েকদিন পারবো, তারপরে না পারলে আমি চেষ্টা দেখবো যদি অ্যাডভোকেট সাহেব ধরা যায়। যে কয়েকদিন পারছি।
আপনি কি কোনো এফিডেভিট ইন অপোজিশন দিতে চান এই মামলায়?
ম্যাডাম দিতে চাই, দিন সাথে আমি সময় চাই।
ভেরি গুড, ঠিক আছে।
আর একই ধরনের
My lord, in that case,
চলছে, মানে এই কেসটার দুটো পার্টি আছে।
আপনি অপোজিশন এগুলো সব লিখে ফাইল করুন।
আচ্ছা, ঠিক আছে।
হ্যাঁ, আর অন্য রেসপন্ডেন্টদের এবং পিটিশনারকে কপি দেবেন।
এতগুলো কপি ম্যাডাম, শুধু সাবজেক্ট ম্যাটারটুকু দিয়ে কপি তো ওনাদের কাছে পুরোপুরি আছে, সেই ফোরাম থেকে চলছে। মানে
আপনি
এত
ফাইল
টাকা
করুন,
পয়সা
তারপর দেখা যাক। আপনি ফাইল করুন, অপোজিশনটা ফাইল করুন আপনি।
আচ্ছা, ঠিক আছে।
My lord, if my lord grants only 2 weeks, my lord, I would be needing to get the documents. I need to check from my client also if they have
আপনি 2
received it.
সপ্তাহের মধ্যে ফাইল করতে পারবেন?
হ্যাঁ, আমি এক
So
সপ্তাহ।
let the reply be within 2 weeks and the
My lord.
opposition also be within 2 weeks.
My lord.
Affidavit in opposition filed on behalf of the first opposite party is taken on record. Paragraph, learned counsel for the petitioner seeks to use a reply to the said affidavit. Paragraph, affidavit in reply be filed within 2 weeks from date. Paragraph,
Respondent number 15.
opposite party number 15 appearing in person seeks to use an affidavit in opposition in this matter. Stop, such affidavit in opposition be filed within 2 weeks from date. 2 সপ্তাহের মধ্যে ফাইল করুন। Paragraph, let the matter appear, like it again, the matter be placed before the next available circuit bench. Paragraph, the interim order granted earlier is extended till 31st May 2024 or until further orders, comma, whichever is earlier.
my lord, one indulgence, my lord, in the appeal to opposition, my lord. The name of the number of the cases has been wrongly mentioned. It is just written as 128, actually it is instead of 125, my lord.
128 is also there.
Also there.
Also in both you've stated 128. Very good. So please do the necessary correction. একদম শুরুতে করুন যেখানে opposition file করেছেন লিখলাম না হ্যাঁ তারপরে লাইন opposition file is taken on record তারপরে on prayer of the first opposite party comma liberty is granted to correct the number of the application in the said affidavit. Please do the necessary correction. Next. You're the petitioner. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 30th April 2024. Yes.
Lordship,
You are appearing for?
I'm appearing for OP number 1. On the last occasion, my learned
So
friend,
who has not been served? Several OPs.
Lordship, all the OPs are already experty in lower court.
Service has to be complete.
Service has to be completed.
If they do not appear despite service, it can be heard expertly. Yes, but the minimum requirement is service. So let him come back after service.
Lordship, two chances are given. So my submission, let there be at least in the next occasion, my learned friend should not submit in such a.
Please complete service and come back, right? Next circuit, because there are several opposite parties. Since service upon all the opposite parties is not complete, comma, the matter be placed before the next available circuit bench. Next. Twenty-four. Passed over. How many matters can I hear on 30th April? On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 30th April 2024.
My lord, I am appealing for the opposite party.
Petitioner? Passed over. Let it be passed over for some time. Passed over. Petitioner, yes. 87B. Have you served?
Is your lordship taking up item number 27, your lordship?
Yes.
Lordship, item number 27, I appear on behalf of the petitioner.
Petitioner?
I'm sorry, I'm in 28. I'm sorry, I'm in 28. Extremely sorry, extremely sorry.
Service was not complete on the earlier occasions also.
Lordship, the affidavit of service is ready. It is showing item dispatched in the month of January. I have sent, Lordship. Today I checked the track record is showing back.
Back?
Item bagged.
Bagged?
Back,
Oh.
P-A-G-G.
It has to be delivered. So please serve and come back.
So
it's short matter, I'll fix next week. Please try and serve.
let me serve upon the opposite party as well as the advocate. There was the interim order.
There's an interim order.
Earlier there was an interim order.
5th February. Expired long back. Come back next week. I would just like to have the representation. Very short matter can be disposed of, right? 30th April. Since service upon the opposite party is not complete, comma, let the matter stand over till 30th April 2022.
In the meantime, service upon the advocate and let there be direction.
Paragraph on prayer of the petitioner, comma, liberty is granted to serve notice upon learned counsel appearing for the opposite party before the learned trial court, in addition to service upon the opposite party.
Advocate.
Advocate in addition to the opposite party, because it's already on serve. I mean, on the way. The delivery track report is necessary. If the advocate comes and represents, we can deal with the matter. Please try that out.
26, my lord.
27. Yes, 26. You are for?
For the petition.
Oh, I had just passed it over. 26 are reading. I'll get 159. For the opposite.
Possibly largest have served copy now. In a proceeding under section 8 of the Land Reforms Act, my lord,
Yes.
at the time of adducing evidence, it has come to the notice of the court that the petitioner, that the original petitioner number 3 had expired long back. No steps were taken, my lord. Now suddenly after that, the legal heirs of
The petitioners are the opposite party is there.
Yeah.
For the news.
no petitioner.
Yes, preemption filed by
the-
the opposite party.
Yes.
Right.
Yes.
Yes, that's exactly
Yes,
what
the
I was
preemption.
asking.
Well, thereafter the legal heirs of that deceased petitioner has filed application under Order 1, Rule 10, my lord.
Yes.
Well, since the proceeding has already been abated against that person, my lord, whether that application can be that the names of the legal heirs can be included through that process or not, that is the main question here.
That's why they have not come through that process.
Yes, they have not.
They have come
not,
through the other process.
Yes.
Order 1, Rule 10.
They
Is
have
there
come
any
through
bar?
Order 1, yes.
They want to be joined independently.
But this cannot be, my lord.
My lord, several judgments are there. If the one of the
It has
legal
to
representative is
their
in all,
process
is
is
on
that-
record, is representing, then there no question of abatement arises.
Then why they
My
are
lord,
being
the
added as a party?
there are
Then why they are
several judgments of
why they are asking to be added as a party? So they has to first ask for setting aside of the abatement, my lord.
My lord,
Then substitution.
They have filed Order 1, Rule 10 to, because, my lord, if the right comes, my lord.
Gita Burman has expired.
No, my lord, Ananta Burman, he has expired, my lord. Ananta Burman, initially Ananta Burman, along with his 2 sons, they filed the preemption case. Thereafter, Ananta Burman died. Now, my lord, Ananta Burman had another son who already expired. Now, my lord, by Order 1, Rule 10 2, the wife of Ananta Burman, 2 daughters of the Ananta Burman, and the wife of the deceased son of the Ananta Burman, they filed an application under Order 1 to Rule 10 2. Now, my humble submission before your lordship, it's a preemption case. It's not a declaratory, my lord, declaratory suit, my lord. So, my lord, if there any legal representative is representing the case, so there is no question of abatement. Now, the question which has been raised by my learned friend, that why they now, in that case, why they have come by filing Order 1, Rule 10 2. Now, my lord, if the preemptor wins, my lord, he is the grandfather. Everybody has the right. All the legal heirs has the right. Therefore, they have filed Order 1, Rule 10 to implead themselves as the party in the proceeding. And there are a number of judgments.
And Malu, can you see
kindly see
the stage when they have preferred this application, Malu?
Yes.
Can you see the stage when they have preferred? It is the cross-examination was going on at that stage, my lord.
Lordship, kindly come.
And there is no explanation in the petition, my lord. Why they could not file, come at an earlier stage, my lord.
That has been
Is there
clarified.
any legal bar?
Yes,
Well,
at
since
any
it has been,
stage.
since it has, the proceeding has been abated against him, so unless it is set aside, the abatement
His
is set
legal
aside.
heirs are already on record.
Well,
So
that
does
has-
the proceeding await?
No, the others are here, my lord, not the,
Where is the preemption case?
who has filed the application, can you see? The other,
Have you annexed it?
Yes, my lord, page 14, they have annexed. Page 14, lordship, kindly see that Sri Protul Chandra Bormon and Sri Nokul Chandra Bormon, they are the sons of Ananta Chandra Bormon. They are in on record, they are representing. So the question of abatement, my lord, does not arise. My lord, so
The
many
heirs are
judgments
already on record.
on
who has preferred the
record.
application, my lord, can you see?
The other
Yes,
heirs,
madam.
yes, they claim to be necessary
Yes,
parties.
unless it is substituted, how they can come?
My lord, since
Can they,
there is
can they evade that process, my lord?
Can't they come under Order 1 Rule 10 if
Well,
they're
how,
necessary
Lord?
parties?
Yes, they have to abate, first the abatement has to be set aside. Then
Where
only
is
they
the
are
abatement, sir?
substituted.
There
They have to
cannot
give
be an
explanation to that.
abatement. I'll pass necessary order. There cannot be an abatement when two of the
Wait,
legal
Puja,
heirs are there. They are
Lordship,
being represented.
I leave it to you, Lord.
Lordship, kindly go through this judgment also, and regarding the limitations, my lord, I have also another judgment. Lordship,
Judgment paragraph,
my
the
lord,
one that you've
the
given.
first one, Lordship, kindly read the paragraph
কোনটা সাইট করছো বলো?
36. Paragraph
Citation টা?
36. Yes, 2023 Live Law SC 261. This is one judgment, and the second one, এটা দিয়ে দিচ্ছি। Mother, kindly see the second page of the second one judgment. Paragraph number 8.
Second judgment.
Second judgment is 2016, volume 2, WBLR SC, page 24, paragraph number 8.
Yes.
And my lord, this is the last one regarding the limitations. এটা হচ্ছে 2017 ভলিউম 4 WBLR CAL page 145.
Page, paragraph,
Which one, Lordship?
the third one. On the limitation ground.
Part one, my lordship, kindly see the head note, lordship.
Head note is deceptive, isn't it?
Kindly go to paragraph 12.
The last one.
When did the original petitioner die?
My lord, 2016, lordship.
And your application was filed, not?
Wrong back on it.
19.
Yes,
after
your
3
lordship.
years.
Paragraph 4. My lord, I have explained in paragraph number 4.
The second application, first they are not pressed.
Yes, do you have anything to add?
No, madam. I leave it to you, Lordship.
Third learned counsels for the parties. Paragraph. The petitioner has essayed the order of the civil judge, junior division, to Fungunj, dated 25th July 2022, allowing the application of the opposite parties filed under Order 1, Rule 10 within bracket 2 of the Code of Civil Procedure, read with Section 151 of the Code, C capital. Paragraph, learned counsel for the petitioner submits that after expiry of
Years, my lord.
3,
Nearly 3 years. Because,
after submits that the application has been filed after about 3 years of the expiry of the third petitioner, Ananto Chandra Burman, the third petitioner in the mispreemption case being number 7 of 2014, Ananto Chandra Burman. The case abated in the meantime, despite which the opposite parties, instead of praying for setting aside the said abatement, filed an application for addition of party
an application is at page 25.
by application for addition of party by circumventing the procedure under Order 22 of the Code. That is your submission.
And my lord, at the time of prosecution, it was revealed, my lord, that the petition number 3 has expired, my lord. Then they came up with this application.
Learned counsel further submits that expiry of the third petitioner in the miss case came to light during cross-examination of the witnesses, following which the application was filed. Paragraph. In refuting the contention of the petitioner, learned counsel for the opposite parties submits that since petitioner numbers 1 and 2, who are the legal heirs of the deceased petitioner in the miss case, were already represented, there was no question of abatement of the miss case. Stop. Also, the law of limitation does not apply to an application under Order 1, Rule 10 within bracket 2 of the 10 bracket 2 of the Code. Stop. The delay in filing the application has been sufficiently explained in the application itself. Since the opposite parties are also the legal heirs of the deceased, in addition to the other petitioners in the miss case, they sought to be added as parties therein by an application under Order 1, Rule 10 within bracket 2. Stop. Learned Counsel has placed reliance on the authorities in Banwari Lal, বাকিটা লিখে নেবেন, comma, ওই এটা reported in পুরোটা বলবো, Banwari Lal bracketed dead, within bracket dead, by legal representatives and another versus Balbir Singh, reported in 2016 within bracket 2 WBLR within bracket SC 24, comma, Rajia Sultana Khan and another reported in and Shiv Shankara and another reported in so and so in support of her contention. Paragraph. It is not in dispute that petitioner numbers 1 and 2 in the Miss case are legal heirs of the deceased petitioner Ananta Chandra Borman, and the opposite parties herein are also his legal heirs. Stop. Admittedly, the deceased was not substituted by the present opposite parties in accordance with the provision laid down under Order 22. Stop. It is right law that when the deceased is already represented by his legal heirs in a case, comma, the question of abatement of the case due to expiry of the deceased, due to his expiry, does not arise. In the paragraph, in the authority in Banwari Lal within bracket Supra, comma, the Honorable Supreme Court has held that the prescribed procedure cannot be circumvented by filing an application under Order 1, Rule 10 of the Code of Civil Procedure, but it would be unjust to non-suit, non-suit, SUIT, non-suit the appellants on the ground of technicalities. That is exactly what you were saying.
It is not that the defendant, the opposite party has expired, they did not have the knowledge. It is their own father had
Yes,
expired,
yes.
they did not take any step.
But it doesn't abate because 2 other legal heirs are already on record. We cannot abate.
And there is no explanation as to why, what caused the delay. There is no explanation at all.
Even if it is held that the application under Order 1, Rule 10 was filed in order to bypass the rigors of an application under Order 22, comma, such application cannot be rejected on such technicalities. Since the opposite parties are also the legal heirs of the deceased, in addition to the other petitioners in the miss case, comma. Delay in filing the application under Order 1, Rule 10 ought to be condoned. Paragraph. In view of the above, this court is inclined to hold that the order impugned does not suffer from any infirmity which calls for interference by this court. Paragraph. In the result, the application being CO 159 of 2023 is dismissed. Paragraph. The order dated 25th July 2022, passed by the Civil Judge Junior Division, comma, Tufanganj, in Miss, within bracket preemption, bracket closed, case number 7 of 2014 is affirmed.
Grateful.
Poison certified website copy.
Grateful.
এগুলো দেখে নেবেন না? ওগুলোর সাথে নেক্সট
Item 28, Your Lordship, I'm appearing on behalf of the petitioner. Lordship, will it be a pleasure to kindly adjourn the matter and keep it on Monday, Lordship? And Lordship, Miss Agarwal is appearing and she has the affidavit of service of the CRAN that we filed for extension of the interim order. That affidavit of service is there, Lordship. If Your Lordship so pleases, Your Lordship would kindly extend the interim order already passed.
who is appearing for the opposite parties? The interim order has expired in January.
Yes, Your Lordship. And this application was filed during the continuation of the interim order.
Right.
The interim order expired on 26th of January, Lordship, and we filed this CRAN on the 24th. We filed it in time.
Have you served the opposite parties? Where is your affidavit of service?
Lordship, the CRAN, I'm told, has been filed. The affidavit of service is what my learned friend is handing over to Your Lordship.
The application, the main
And the main application, Lordship, I would be very candid. The main affidavit of service is lying with the client, Lordship. And due to paucity of time, we could not give it to the learned.
CRAN has also not been served. The last
CRAN
endorsement is item bagged. So that is not service.
Lordship.
Please come
Lordship
back.
would then kindly adjourn it till Monday, Lordship. And in the meanwhile, we shall serve and come.
Can you come back so soon or let it be on Wednesday?
Lordship,
Right?
Lordship Wednesday.
Since, please take this back. You need the postal receipt. Since service upon the respondents is not complete, comma, CRR 355 of 2023 with CRAN 1 of 2024. Since service upon the opposite parties is not complete, comma, let the matter stand over till 1st May.
Lordship, match obliged.
Next.
For the state. And Mr. Navankuri is on behalf of the petitioner.
Where is he?
Just to this matter.
Passed over.
Worship, I think he said the matter may be fixed on Monday. They will not get.
Yes.
Item number 23.
Item number?
29. My
Yes.
apologies, my lord. Praying for next circuit, my lord, due to the personal difficulty of the advocate on record. he could
Next
not-
circuit.
Next circuit, my lord.
Worships,
Is there an
see
interim?
the conduct as because the order has been passed on first order on 2022, and thereafter once the matter was adjudicated before your lordships, but now they are dragged. So I am holding the CD since 23, your lordship.
Why are you holding it? Give it back.
Lordship,
Get it again.
yes, nothing as because when the matter is pending before your
If
lordship,
you're holding the CD, the
And the-
investigation is stalled.
even they have filed a petition before the lower court that the matter is sub judice before your honorable court. So lower court has no.
There is no stay. There is no stay.
So
Such
lordship,
can
then,
proceed, might as. There is no difficulty in proceeding with the matter. On prayer of the petitioner, the matter be placed before the next available circuit bench.
Grateful, my lord.
Next. Yes.
But I have the opposite party.
Lordship, the state has preferred this revision. And Lordship knows that on the other day also, we moved that double AG will appear in this matter. Now, just now we have received the CD. Let's just see the voluminous CD. In fact, the double AG is not in the station today. He is due to some administrative works. So he requested me that any day next week he'll do it.
Mr. Ahmed has come back.
I really do not wish to come in the next week. This is the matter blood.
Why this week Darjeeling, next week Kurseong or Kalimpong?
Family blood is does not allow all of this. This is a matter blood which is a pure point of law, whether the act will apply or not. Now, your lordship is aware that the substantive law is not given a retrospective effect. But my learned friends, their contention is that the act will apply in this case, though the offences has been made after the act is promulgated. That's a very small point of law. That
When can you come back?
Double AG will any day next week.
Next
Your
week will
lordship,
be
kindly
difficult
fix
for
it.
you.
Lord, I'll be relying on 2 judgments and Lord, 3 judgments, and Lord, factual aspect is not necessary because of the reason, Lord.
You're asking for the next circuit.
If they are I'll be doing it virtual.
No problem.
Mr. Shahabuddin will be here to assist you.
Second May.
Second.
Second May.
Second, Lordship knows that.
Oh, you have a difficulty. So,
First or third?
First. Third is the last date. Nothing happens on.
No.
First May. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 1st May.
First May was a holiday previously.
No, there's no holiday.
Nowadays, it's not. We have adjusted with the shop.
I think the district court has a holiday on first,
Yes.
not the high court.
Item 31.
Lordship, 31, I am for the petitioner. I am ready with the matter, but only one indulgence. Can it
Then
be
there's
taken?
one but.
Can it be taken on 2 p.m. because I have a matter out there. Mr. Ahmed is on the other side.
I'm opposing him.
Lordship, I am for the state 31.
At 2 p.m. I have a matter out there.
You don't need to go back. I'll let it.
I'm here today.
So shall I hear it at 2 p.m.? Come back at
I'll do it. Certainly, I'll do it. Grateful, Lordship.
There is another matter I trouble your lordship at 2 p.m. because 65.
32.
Am I audible, Your Lordship?
Yes, you are.
Lordship, if Your Lordship recalls, yesterday, item number 83, CRR number 270, you fixed it with today's item on
Yes, this is
2nd
the
May.
other matter. This is the other matter.
Yes, Your Lordship.
2nd May is the
Fixed date. Yes, Your Lordship.
On prayer of the petitioner, let the matter appear under the same heading on 2nd May 2024. Let them appear together.
Grateful, Your Lordship.
Next.
Item 33.
Yes,
33.
passed over.
34.
Yes, 33. You're appearing for the petition?
Petitioner.
Yes.
My lord, 33, I am for the petitioner.
Yes. Have you served?
Yes, my lord. Mr. Ganguly is appearing.
33.
Ganguly is in the division.
Just pass.
So I'll pass it over.
Must. Gotcha.
Next,
34.
34, passed over.
35.
Lordship, I am for the petitioner, Lordship. This is an application under section 482 for quashing of the FIR, Lordship.
Yes.
The petitioner number 1 is an engineer by profession and working in NHPC of Vale, and the petitioner number 2 is the wife of the petitioner number 1, Lordship. And the instant FIR is lodged under section 376, 328, 509, 506, and 323 of IPC.
Have you served the second?
Yes, Lordship. Since long, Lordship, I have filed the affidavit of service on last occasion. The order is also recorded.
Yes, sir.
Yes. Lordship, kindly see the paragraph 3 of my application, Lordship. Opposite party number 2 in connivance with one Rajesh Pal and his son Sri Shobhik Pal has stopped a conspiracy under which they had introduced this petitioner to allow them to invest huge amount of money for purchasing various life insurance and the health policy. The opposite party number 2 is the insurance agent, Lordship. And subsequently, the said person jointly and severally committed the following offences, Lordship. Actually, Lordship, the petitioner in this case lodged a FIR against the complainant of this case, opposite party number 2. The allegation number 1 is making of unwanted insurance companies traditional plan for different agencies like Reliance, Max, Tata AIG, SDFC, and Star Health, LICs, etc. Allegation number 2 is cash transfer amounting to rupees 56 lakhs to the personal bank account in the name of 26 number of brokers account on false information over a span of 2 years. Allegation number 3 is doing multiple fraudulent transactions from petitioner's credit card, and instead of making petitioner policy, they have done in name of the outsider and collected cash from them, and they are not providing details from the first day till date. And allegation number 4, intentionally blackmail through seduction act, Lordship. Over this allegation, on 12th March 2022, there is a FIR lodged, Siliguri PS case number 270, dated 12/3/2023. Lordship, subsequent to lodging this FIR, the de facto complainant of this case prayed before district Darjeeling for obtaining bail. The bail was refused, and subsequently she had filed another application before the Honorable High Court, and Honorable High Court also refused her bail. Subsequent, the bail was rejected on 10th August 2022. The date is very important, Lordship, kindly note it, 10th August 2022. Subsequent to rejection of this FIR, Lordship, the de facto complainant lodged a complaint on 14th September 2022. Before lodging this complaint, Lordship, kindly takes up annexure P1, page 14, Lordship. Before lodging this complaint, this is page 14, Lordship.
14,
yes, 14. May I read? May I read? Dear Mr. Shah, আপনি প্রতিটা অফিসে গিয়ে আমার নামে রিটেন কমপ্লেন্ট দিচ্ছেন, তো কিসের জন্য দিচ্ছেন? আমার ক্যারিয়ার নষ্ট করার জন্য। বাট একটা কথা বলি, আমি ক্যারিয়ার আপনার নষ্ট করে আমার ক্যারিয়ার নষ্ট করতে পারবেন না, বিকজ আমি কোনো ভুল করি নাই। আর হলো পালিয়ে বেড়ার কথা, পালিয়ে আমি বেড়াচ্ছি না। আপনি যদি সাথে সৎ সংস্থায় থাকে, আপনি নিজের সবাইকে সব সত্যতা বলুন। ভাবছেন নিজের বাঁচবো, আমার ক্যারিয়ার নষ্ট করে আর ফ্যামিলিতেও ভালো মানুষ হয়ে যাবেন তো? এইটা সহজ নাই, আমি কোনো ভুল করি নাই। চাইলে আমি আপনার টাকাগুলো নিজের করে নিজে নিতে পারতাম। আপনার লাভ দেখার জন্য আমি কিন্তু সেটা করি নাই। আপনি যদি মনে করেন এখন আমাকে ফাঁসিয়ে সবকিছু নিয়ে পালিয়ে যাবেন, সবার কাছে ভালো হবেন, তাহলে তো ব্যাপারটা আমাকে দেখতে হবে। কালকের 12টা PM এর মধ্যে আপনি আমার এগেনস্টে যা যা কমপ্লেন করেছেন সব যদি উইথড্র না করেন, আপনার অফিস, রাজেশ পাল, সৌগত রয় চৌধুরী, বিমল কুমার, সবাইকে সব দেখাবো। আর আমার লিস্টে ফার্স্ট প্রায়োরিটি আপনার মিসেস। বাঁচতে চাইলে আপনি কাল সকালের মধ্যে সমস্ত কমপ্লেন্ট উইথড্র করে স্যাটারডে আমার সঙ্গে দেখা করেন। আর যদি সম্ভব হয় পার্সোনালি ফোন করেন, নয়তো কিন্তু খারাপ হবে। FIR আমিও করতে পারি। আর ভাবেন এইভাবে আমি কমপ্লেন করতে পারি। থ্যাংক ইউ। শ্রেয়সী মিন্স কমপ্লেনেন্ট নেম। কাজ করে স্যাটারডে আমার সাথে দেখা করবেন, আপনার হেল্প করব, ক্ষতি নাই। আমি চাই না আপনার নেক্সট পেজ লর্ডশিপ, পেজ নাম্বার 15, আমি চাই না আপনার শেষ জীবনটা নষ্ট হোক, তাই আমি মেলটা করলাম। হোয়াটসঅ্যাপে করতে পারতাম, বাট আপনার মিসেস সবটা জানবে বলে আপনার সামনে রাখার জন্য এই মেলটা করলাম। ভালো চান, যা যা কমপ্লেন করেছেন সব কমপ্লেন উইথড্র করেন, স্যাটারডে আমার সাথে আপনি মিট করেন। She was continuously insist him to meet. And next on 3rd March, she has sent another mail. Aaj next page logic, page number 16 logic. তার মানে তুমি কমপ্লেন্ট উইথড্র করবে না তো? ঠিক আছে, আমি ভেলে গৌতম দাস কলকাতা অফিসে এই ফটোগুলো দিয়ে দিচ্ছি। সরি, আমার কোনো অপশন নাই, আমার ক্যারিয়ার শেষ হয়ে যাচ্ছে, এবার আমি কাউকে ছাড়বো না। গৌতম দাস, ফোন নাম্বারটা একটু কনফার্ম করবেন। গৌতম দাস, হি ইজ দ্য son of the petitioner logic. That the number was given of the son of the. On 3rd March, she sent a photograph logic, পেজ নাম্বার 17। স্যাম্পলটা পাঠাচ্ছি। গৌতম দার তোমার ওয়াইফকে কাল সকালে 10টা অবধি টাইম দিলেন, যদি কমপ্লেনটা উঠিয়ে আমি সব ফটোগুলো ভিডিও তোমার ছেলের কাছে পাঠাবো। She has sent this photograph on 3rd March 2022. Page number 17 logic.
This Gautam is not a party to any of the.
No.
matters.
Gautam is the son of this petitioner. She blackmailed that she will show this photograph to his son and the wife. Yes, Lordship. Then actually, Lordship, it is admitted that they had a romantic relation between the petitioner and the complainant, Lordship. But just to take revenge, because she has 2 crore 50 lakhs rupees, just showing and blackmailing this photograph, he has taken 2 crore 50 lakhs from the petitioner, Lordship. When the petitioner refused to withdraw all the FIRs, and when the High Court refused her bail application on 10th August 2022, then 14th September 2022, she has lodged this FIR allegation of rape, Lordship. And the respondent petitioner number 2 is no way connected. Even she herself threatened the petitioner. She will send all the photographs to the wife. How the wife is involved in all this such things, Lordship? She herself
The wife has been granted bail.
Yes, both are on bail, Lordship.
Both are on bail.
Yes. I am filing this application for the quashing of the FIR. The intention is very clear. She has pressurized the petitioner to withdraw the FIR. When he refused, then they filed this false allegation of the rape. The lady is a major lady, they were in a professional relationship, and she herself for the seducing activity, they were in a romantic relationship, and now she started all these things.
Where is the order of the High Court?
Rejection order.
Yes. You have annexed?
Uh,
No.
no, Lordship. But I have the copy of. Having considered the materials on record, a huge amount of allegation by the complainant to appropriate rupees 2.5 crore by way of credit and fraud, the bank transfer, and the seriousness of allegation, we are not inclined to grant anticipatory bail of the petitioner. I have the order copy, but not in this. This was the observation of the High Court that a 2.5 crore was misappropriated by this lady lordship. Yes. Just to take revenge, this FIR was lost. Let us hear the state.
According to the CD, Mala, 161 and 164 statements are there. And it's a fact that regarding the date and all, there is a delay. There is a huge delay of filing this complaint, Mala.
She stated that the first attempted on 2020, as she lost FIR on 2022 after rejection of the High Court. And the and petitioner number 2 is no way connected, lordship. Yes, here there is no it doesn't substantiate. Isn't it? This is a fixed case for the
Sir,
party
what
lordship.
type of, Mala, to be very honest, Mala, it's called, what in one word is called a honey trap. And the
Yes,
people
lordship.
have been trapped. Like,
I
we
appreciate
this,
the
Mala.
PP.
These things we see in the newspaper also.
Yeah. It's long back. After that, 3 dates were fixed, but she did not appear. Let it be posted. Grateful, lordship.
Let me keep the CD.
Yes, I'll just go through, I'll just indicate the reason, because investigation is still going on, isn't
My
it?
lord, just. Rashid filed it.
For learned counsels for the parties. Paragraph. Case diary is produced by the state. Paragraph. This is an application for the application under section 482 of the Code of Criminal Procedure for washing of the proceeding being GR case number 4140 of 2022, corresponding to Siliguri Women Police Station case number 156 dated 14th September 2022, pending before the learned Additional Chief Judicial Magistrate at Siliguri, District, Darjeeling, under section 376/328/509/506/323 of the Indian Penal Code. Learned counsel for the petitioners submits that the second opposite party comma, in connivance with others, comma, induced the petitioners to invest huge amount of money for purchasing various life insurance / health insurance and / or other allied products. The second opposite party duped the petitioners, PUPED, the petitioners of a sum of rupees. What is the total amount?
2.50, 2 crore 50 lakhs.
2 crores and 2,50,00,00,000, 2 crores 50 lakhs. And the first petitioner also had to take a loan for an amount of rupees 1.75 crores through various means like house mortgage, comma, provident fund withdrawal, comma, gold loan and bank loans. Stop. The first petitioner lodged a complaint against the second opposite party before Siliguri police station on 12th March 2022, which was registered as Siliguri PS case number 27T, dated 12th March 2022. Stop. The petitioner, the second opposite party, sought anticipatory bail. It was anticipatory or
Yes, first and second both got, yes.
Anticipatory bail
By district judge.
before the opposite party.
Opposite party, no,
Only
bail was,
before-
opposite party bail was refused.
By only the High Court or even before that?
Before the district court? Yes. both.
Before the district court as well as the honorable High Court, which were turned down. Stop. After the prayers of the second opposite party were refused by the courts, comma, she chose to lodge the complaint against the petitioners on false allegations. Stop. Both the petitioners have been granted anticipatory bail by the district court. Learned Counsel submits that the present complaint is a retaliation of the earlier complaint filed by the first petitioner against the second opposite party, which led to refusal of anticipatory bail to the second opposite party by the High Court. Paragraph. Learned Counsel for the state produces the case diary and opposes the prayer of the petitioners. Paragraph. It appears on perusal of the material on record that complaint against the second opposite party was lodged by the first petitioner on
12th March 2022.
12th March 2022 under sections and 2022 and
404, 420, 560,
under sections 404
420,
slash 420,
465,
465,
467,
467,
468,
468,
120B,
yes,
IPC.
of the court. And anticipatory bail of the, and her anticipatory bail, sorry. And her anticipatory bail was turned down by this court
On 10th August 2022.
10th August 2022. Stop. The present complaint was lodged
On 14th September 2022.
on 14th September 2022, comma, that is, after refusal of the anticipatory bail. Several communications made by the second opposite party to the first petitioner are found on record, which prima facie demonstrate a consensual relationship between them. The case diary does not disclose any incriminating material against the first petitioner, comma, far less against the second petitioner, who is the wife of the first petitioner. Paragraph in view of the above, this court is inclined to hold that the present complaint is a retaliation to the earlier complaint filed by the first petitioner and refusal of the anticipatory bail of the second opposite party. Material available on record warrants an order of quashing of the proceeding in GR case number 4140 of 2022. Paragraph, hence the application being CRN number 68 of 2023 is allowed. Paragraph, proceedings of GR case number 4140 of 2022 corresponding to Siliguri Women Police Station case number 156 dated 14th September 2022, pending before the learned additional chief judicial magistrate at Siliguri, district Darjeeling, is quashed.
Grateful.
Case diary be returned. Urgency referred. CD penalty. Next. Petitioner passed over.
My lord, item number 37, I am for the petitioner, my lord.
Yes.
My lord, I am for the opposite party number 2, led by Mr. Rohit.
My lord, kindly, my lord, have a look to, my lord, the order dated 27th September 2023, my lord, passed by Justice Ghosh, Justice Tirthankar Ghosh, my lord. Kindly produce the order, my lord.
36.
37, June.
Give me a minute, please. 36 has appeared. So let me just.
Oh, yes,
Just a minute.
My lord, my lord.
It can be taken up for final hearing on the next week, any day, Lordship. Second.
All matters.
No, I'm otherwise ready because I need some judgment, Lordship. That's right. Otherwise, I'm ready.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 2nd May.
Second, Lordship.
Have been a stay or?
Wait.
My lord, I am for the petitioner, my lord.
Yes.
My lord, kindly peruse the order passed by this honorable court on 27th of September 2023, my lord. Passed by Justice Ghosh, my lord. In the second paragraph bottom, my lord, there was a direction upon the state.
My lord, sorry to interrupt. My lord, in this case, Arjun suffer throat problem, so he is unable to come. Let it be on Monday.
No, let it be on Monday, my lord. Kindly see one thing, my lord. I'll just indicate, my lord. There was a direction upon the state. There was a specific, second paragraph, last line, my lord. That state shall provide some bunch of documents within a stipulated time has been given by this court that this document should be supplied to the petitioner as well as to the opposite party. That has not been supplied till date.
Have you amended the cause title as in terms of this order?
Yes. That has been amended and supplied to served, my lord. But there was a direction upon the state to supply these documents by 19th of October 2023, which they want to rely upon, my lord. That bunch of documents, without this bunch of documents, we cannot proceed with the hearing of the case, my lord.
Yes, what about these documents?
Lordships, actually, his junior said the report has come. So I don't.
You are not appearing for the state?
No, state appearing for the Arjun Choudhury.
He is appearing?
Yes, Lordship. So, Lordships, if it is fixed on Monday, we will come with along with the report and the proper address.
Well, a report, what purpose will serve by the report? Well, there is a direction upon the state to furnish some copies to us.
The opposite party number 2.
That has not been complied with till date.
You are not aware.
Yes, I will.
Let it be fixed on Monday. Let it appear on
My
Monday.
lord, we shall come.
On prayer of the state, the matter is adjourned. Paragraph, let the matter appear under the same hearing on 29th April 2024.
Deeply obliged.
Next.
I'm for the state, my lord.
Lord, I am for the petitioner in this matter. Vatsal Verma is appearing on behalf of the petitioner. He could not come to the court because of ensuing parliamentary elections held tomorrow, my lord, at Darjeeling. My lord, I am praying for not today, my lord. Only not today, my lord.
Not today. So all the matters will be on Monday.
On Monday.
In item number 39, my senior will be appearing this matter. He is suffering for throat infection. He is unable to speak properly, Lordship.
So,
Lordship, kindly make it next week, Lordship. Any day, Lordship.
He'll be all right next week.
Lordship.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 2nd May.
Lordship.
Next.
Lordship, I am for the petitioner praying for next circuit, Lordship.
On prayer of the petitioner, the matter be placed before the next available circuit bench. Next.
For the petitioner. I'm for the state. The issue is very small, Lordship. I have challenged the impugned order whereby the prosecution document has partly been supplied and partly been deferred. I have pointed out, I have taken out an application. I being the accused person has taken out a specific application narrating what sort of document I have been withheld to supply by the prosecution. That's why I'm praying for it. I paid before the learned trial court that this particular document need to be supplied to me to defend my case. On this particular.
You are the accused before the trial court?
Yes. So on this court, I filed this application. That prayer has been turned down. Therefore, this is not the wholesale non-supply of document, not that the case. The particular
some of the documents
has not been supplied. Yes. I believe this is
have you served the private opposite party?
No, private opposite party. Yes, I served it.
There was a direction on the.
Yes, I served it, but learning for public prosecutor is there.
Private opposite party.
Private opposite party. Private opposite party is the.
Where is the service?
Government office.
Alok Roy. But you have implicated him in his personal capacity, not as a government official.
No, all of us appear from the original. Sorry.
No, no. I do not find the service. There was a direction.
Service told me.
Mr. Ojumdar, are you appearing for the private room? No. Okay. Where is your affidavit of service? Is it served?
No, perhaps not, sir. Perhaps I'm not sure.
Then
The government is, sir,
you pleaded him as a party. And there's a direction for service.
True, but the thing is, he's a de facto complaint. Otherwise,
My lord, actually, my lord, fairly submitting before your lordship, my lord, in this case, in this situation, my lord, de facto complaint is not required. Actually, only purpose.
Will you expunge the name?
is there any requirement, lordship?
Yes, you have to either expunge or serve. These are the two options left.
Lordship may be expunged on the he may be expunged.
Only just supply the eligible copies.
Are you opposing this?
No.
No, very well.
207 speaks clearly.
Yes,
my lord.
absolutely.
How can it be, my lord?
Absolutely. Where is the order of rejection?
No, actually, there is no rejection. Actually, there is a direction to.
No, he has filed an application, he says.
Yes, the order dated 8th of December 2021.
You're asking for the documents in column number 10 of the charge sheet, right?
Yes, that has been pointed out in, and I have annexed it. Because the my application is at page 35 of the application, page annexation 5.
Page 35.
Yes, 35. 35 and 36 onward. The column 10. These are the particular documents I need. Very specific, my player.
So you're agreeing to supply copies of these documents, right? The petitioner who is an accused in GR case number 2169 of 2012, pending before the learned additional chief judicial magistrate, Alipurduar, filed an application before the court, praying for copies of documents relied upon by the prosecution in column number 10 of the charge sheet. Stop. The prayer was turned down by the learned court by an order passed on 8th December 2021 with an observation that if further documents were produced by the prosecution during trial, reasonable time would be given to the defense for cross-examination of the witness on the said documents. তো ওখানে ডিপেন্ড অবজারভেশন বল না কি বলে হ্যাঁ কমা ইন্টার এলিয়া কমা The learned court has also recorded that sections 311 of the Code of Criminal Procedure and 165 of the Evidence Act have given ample power to the court to take any decision at the appropriate time. Stop. Such paragraph, such an observation is unknown to law and militates against the provision of section 207 of the code. Paragraph. Learned counsel for the state, comma, submits in all fairness that the state shall make over copies of the documents as asked for by the accused petitioner. Paragraph. In view of the above, nothing further remains to be adjudicated in the present application and the same is disposed of. Paragraph. The state/opposite party is directed to make over copies of documents asked for by the accused petitioner in his application filed before the learned Additional Chief Judicial Magistrate, Alipurduar on. When did you file the application? When was the application filed?
So I'm granted it. It's 35.
Yeah, date was. Only filed an application.
16th of October 2019.
On 16th October 2019. Within 2 weeks?
Within 2 weeks.
Within 2 weeks from date.
But actually, election process is going on within 4 weeks.
Within 4 weeks from date.
The impugned order may be. Impugned order.
Yes. যেখানে nothing further remains বললাম disposed of ওখানে করুন the order impugned. The order impugned dated is accordingly set aside. তারপরে ওটা আছে একদম হ্যাঁ সার্টিফাইড ওয়েবসাইট করবে একদম শুরুতে করুন on prayer of the petitioner, comma. The name of Alok Roy, comma, ALOK, ROY, Alok Roy, comma, the second opposite party be expunged from the cause title of the application. Stop, the cause title be amended accordingly.
Great.
Next. Disposed of. আগেই বলেছি disposed of, দুবার থেকে Next. Petition.
On a rare occasion, I get to stand his side.
That's why I asked.
Lots of the petitioner in this case, Papia Sarkar alias Najma Sultana, she went missing and a diary was lost with the concerned police station, which was subsequently converted into a case of kidnapping. Now, that very person is before your lordship asking to quash that very FIR.
The victim.
The so-called victim, because she went of her own will, got married, actually, my lord.
She was a minor?
appreciate- No, my lord. My lord, kindly notes the second name, alias. And the cause title of the petition.
Yes.
And the husband's name. So there the tussle came up.
Who is?
41.
Papia Sharkar is the so-called victim.
She married.
She's a married lady.
She got married against the husband and his family. The FIR was lodged. Unknown miscreants, first it was unknown miscreants, subsequently their name transpired and their
And
case
this
was
is the
instituted.
father.
Father is
OP number 2 is the father.
Father.
OP number 2 is the father. Have you served?
No, my lord, copy not served.
Copy not served. Who is appearing for OP number 2?
Private respondent.
My lord, then kindly keeps it next week. I will get it served.
Because I do not find the affidavit. of
No, my lord, I think it's missed because it was filed in Calcutta. It was sent down to Calcutta.
Oh, so please.
So my lord, kindly keeps it next week. I will get it served by the way.
2nd May.
My lord.
Short matter can be disposed of.
My lord, Robert,
Since service upon the upon the opposite parties is not complete, comma, let the matter stand over till 2nd May 2022. Please serve the private OPI.
Yes, my lord.
Next.
Lord, in this matter, Milord, in this matter, I am led by Mr. Sanjay Chakraborty, Milord. Another 2 revisional applications are pending between the same parties.
Yes.
My lord, kindly tag those 2 revisional, keeps it on
I
Monday,
don't
Milord.
know about this final lot. The copy has not been served. I am not informed on nothing.
Milord, I shall serve here and now.
So how can those matters be be tagged with this matter? This is that they have come before your lordship formula quashing of the complaint case. And this is the 498, 306, 34 of the Indian Penal Code, and this is the pending. How they can?
Milord, another 2 revisional applications, that is Sierra 24 and 25 or 2024 has been filed by the same petitioner.
Give the
Milord.
numbers, I'll keep them together.
Together
I'm
and
not passing any order.
Yes,
I'll
Milord.
just adjourn the matter, let them appear.
In the meantime, I shall serve.
Those matters, I don't have even.
Let it appear. Let me see the stage of the application. You'll be served a copy, don't worry. Let the matter come before the court.
Yes. I'm grateful, Milord.
Number, please give the.
Milord,
reference.
I shall.
On prayer of the petitioner, the matter is adjourned. Petitioners. Let the matter appear under the same heading on next circuit.
Milord, Monday.
How many matters on Monday? All the
Milord,
matters
Tuesday,
Monday
Milord.
not possible, Milord. Kindly make it not Thursday.
are 2nd May. Next. Passed over. Passed over.
For the petition. This is the past because only the Bishop is holding the CD and under the case. The matter is very simple. I'm very, my only no was clear. Can you without hearing the one. My lord, can you see the internal page number 13?
Why didn't you come back?
My lord.
Why did you? I'll just pass it over.
That's not a problem. Actually, my humble prayer would be the matter may be modified concurrently instead of consecutive. The order was passed, all the sentences will run consecutively. And my humble prayer, that may be modified to that extent concurrently.
If it's a conscious order, cannot be modified. Let me see. Yes. Next matter. Oh. 47. First.
47, ma'am, I am praying for not this week.
47.
The matter is adjourned. Paragraph, let the matter appear under the same heading on 1st May 2024.
48. 48.
Passed over.
49.
Passed over.
50.
49. Yes.
The division application against the impugned judgment and order of conviction affirmed by the Learned Additional Session Judge against by affirming the judgment. The judgment.
Mr. Chakraborty, Mr. Aditi Chakraborty is appearing this.
Aditi and Subhashish Mishra.
Yes.
This matter needs to be heard out on paper book. I don't know paper book has been.
Not prepared?
No. The division against the appeal.
Yes, so let the records be called for. The revisional application assails the judgment and order passed on 23rd February 2023 by the Learned Additional Sessions Judge, Dinhata, Coach Bihar in criminal appeal number 1 within bracket D of 2020. Affirming the judgment and order of conviction and order of sentence dated 24th December 2019, passed by the Learned Additional Chief Judicial Magistrate, Second Court, Dinhata. Paragraph. Call for the records. Paragraph. Paper book be prepared within 6 weeks of receipt of the records. 6 weeks of the next circuit. Paragraph, let the matter go out of list with liberty to mention.
Great.
Passed over. Passed over.
My lord, I am at my lord.
Yes.
Make it a short pass over. My senior is
51.
engaged on. Yes, yes.
Passed over.
My lord, yes.
Passed over.
For the respondent.
Let it be passed over. Passed over. Passed over.
For the state, my lord.
I'll pass it over for some.
My lord, then at 2 p.m. my lord, that's because I will go
Please
division.
come back. Please come.
2 p.m. my lord. 55.
Next.
Your Lordship, I'm for the petitioner. Your Lordship, in this matter, maybe kept on say 2nd May, Your Lordship. This is a very short matter, Your Lordship. It was not appearing in the list and suddenly it came up, so we are not.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 2nd May.
2nd May, Your Lordship. Much grateful, Your Lordship.
Next. Passed over. Passed over.
59.
Passed over.
60.
No, my lord, there are two separate applications. One is main criminal revision application, another is CRAN. At first, if your lordship can you take the CRAN?
Who's appearing? Have you served?
Actually, Madam Sahab, they have appeared. Actually, the item number 11
Yes.
relates with the same matter. That is a matrimonial dispute. Now, my lord, they have appeared. Order sheet itself speaks.
Mr. Aditi Chakraborty.
No,
and
Aditi
Mr. Abhijit
Chakraborty
Shankar.
first state. She is not the answering respondent. There is a private respondent is there. This is a case of 125, my lord. State of West Bengal is not the answering respondent. Now, my lord, the private respondent also appeared. And there is observation in the order sheets. And in so far the CRAN is concerned, my lord, this is the affidavit of service.
I do not find appearance of the private respondent.
My lord, on the in the main application, I was directed to serve the notices, serve the receipts, money receipts to the other side. Passed by Honorable Justice Proceedings Vishwas on earlier occasion. I have served. Ms. Supriya Singh is there.
For the private,
Private
Visit party.
private.
She was here
She was
a while
there,
ago.
no, she was there, was with us in the matter of, in the serial number, item number 11, the same matter.
Yes.
The parties are same. That is matrimonial dispute filed by myself. This is 125 filed by them.
So shall I pass it over? Will you inform her and come back?
I will.
Yes.
I am for the state. No, my lord, one indulgence I am seeking. In spite of having a stay, the wife claiming maintenance in the tune of order passed by the learned trial court, and execution is on, and the learned.
Let's come back. Let me see. Please inform her. I will take it up in the second half. Passed over.
Kindly put the matter on Tuesday. My senior is
61.
Yes.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 30th April.
Grateful mention.
Passed over. Yes, 63.
The 63 I'm for the opposite party. Number 2.
63.
63.
62 passed over.
63, I beg to appear on behalf of the petitioners, your lordship. This is the affidavit of service, your lordship. From the affidavit of service, the last updated date was showing us 23rd of February. That was item bagged, your lordship, but they are appearing, so it
I'm
should
for the
not.
opposite party number 2.
So, your lordship.
Opposite party number 2.
2, my lord.
And I have served up in the state.
Who
as
is
well.
the state?
No, my lord. Who is the? What I have for the state. Complainant, madam.
2 is the
Private respondent, the complainant, your lordship. I have served up.
1 is Oluka Mojumdar.
No, madam, I'm for the 1.
Yes.
Pardon.
Yes, what is the matter about?
Your lordship, the crux of the matter is that the petitioner number 1 got married to the respondent number 1 through a matrimonial site, your lordship, and subsequently they shifted to Seattle, America, your lordship. And after 1.5 years, passing of 1.5 years, they returned back, your lordship, and then she returned back. The marriage was conducted on 22nd of January 2017. Subsequently, the next year, that is on July 16, 2018, she returned back from USA, your lordship. And thereafter, your lordship, she filed, she preferred a advocate's letter to the petitioners, your lordship, by the date 29th November 2018. Subsequent to that, the petitioners, they also replied to that. Again, she replied back, your lordship. And subsequent to all of this, your lordship, a complaint was, CR case was preferred by the private respondent, your lordship, under section 406 and 34, your lordship. And subsequent to that, your lordship, I would like to bring your lordship's attention to the last page of the petition, your lordship, that is the police report, your lordship. The allegation is that they are holding the all the Sridhan property, your lordship. So the police officers went there, inquired, and
Where is the report at page?
At the last or annexure G of my petition in page number 46, your lordship.
Yes.
During inquiry, can I read your lordship? During inquiry, I had been to the house of the accused person, namely Sri Robin Gorai, son of Kartik Gorai of 98 Maulana Azad Sarani City Center, Durgapur, with the consent of the petitioner, Srimati Oloka Mojumdar, and found that as per list given by the petitioner by serial number 29, 30, and 31 are exist in the house and the jewelries having serial number 1 to 17 are kept at the bank locker of the said Sri Robin Gorai, who is now in USA, but power of attorney is given to his father Sri Kartik Chandra Gorai in respect of the said locker as informed by the accused persons. The accused persons are also willing to return the same after obtaining the order of the learned court. I also informed the matter to the petitioner,
Has it
Srimati.
been returned?
She did not wait, your lordship. Your lordship kindly peruse the communication that happened between the parties, that the locker was never opened by the petitioners here in your lordship.
Let them return, I have no case, right?
Yes, your lordship, we are willing to return it. For that, even I have annexed the WhatsApp communication, your lordship, that is annexure 8
When
in
will
page
you return?
45. We are willing to return.
I'll only grant an adjournment.
Your lordship, let them come to Durgapur and take it, because when it was, your lordship, kindly come to
When
page
can you go
45.
to Durgapur?
Presently, my client is at Bangalore, madam. But kindly grant me 10 days time. Or madam, kindly takes it up on Monday. I shall take instruction when she can come.
Your lordship, we are willing to return it.
Let it appear on Monday.
Yes,
Let-
ma'am.
Yes.
I
So
shall
then
be
nothing
expert.
further
Yes,
remains.
madam, I have no case.
And even, your lordship, from the communication also, we have all.
Affidavit of service.
She is also there.
The petitioners have prayed for quashing of proceedings of CR case number 438 of 2019 under section 406/34 of the Indian Penal Code, pending before the learned judicial magistrate, 4th court, Siliguri. Paragraph. Learned counsel for the petitioner takes this court to
46.
report submitted by the SI, sub-inspector, city center, PS Durgapur on 2nd November 2020, which demonstrates that the petitioners / accused persons are willing to return the articles in terms of the list provided by the second opposite party.
Opposite party number 1, your lordship.
Oh, first opposite party.
Page 43 and 44.
Paragraph. Learned counsel for the first opposite party seeks to take instructions as to when the first opposite party shall be able to collect the said articles. Paragraph. Let the matter appear under the same heading on 29th April 2024. Next.
Kindly put the matter on Tuesday, my lordship.
Again, Tuesday.
Actually, my senior is out of station.
On prayer of the petitioner, the matter is adjourned. Paragraph. Let the matter appear under the same heading on 30th April.
Great.
But I think different. Mr. Nilay Chakraborty is appearing, Lord. Let me start, Lord, I'll be, he is in court number 1, your Lord. No, niche khete gaye.
You are coming back at 2 p.m. Come back at 2 p.m.
As a Lord.
Second round.
Yes, Lord, it is already 1.
Second.
Come back at.
Next. Passed over. Passed over.
Kindly take up this matter.
My lord, I am for the appearing for the petitioner, my lord.
Mr. Roy is there.
Yes, my lord. My lord, I'm appearing for the petitioner. My lord, I'm before the principal bench. My lord, one indulgence I'll seek from my lords. My lord, can this matter be taken up on Thursday, my lord? My lord, yes, my lord. 68. My lord, the opposite parties, private opposite parties have been served. The affidavit of service is ready, my lord.
Mr. Ahmed, you're appealing
Yes,
for
Lord.
the opposite
Mr. Roy
parties.
is hopefully not aware that I'm here. Anyway, Lord, your Lordship would kindly
Oh,
take
you're
it
the
up.
petitioner?
Yes. I've just been informed. Yes. I've been informed.
Let it be
My
on
lord, I've
first,
been
let it be
informed.
on
I've been
first.
informed.
First,
First, my lord, because
First, my lord,
Yes,
first.
the case ready. If it is needed, my lord.
Let it come.
First, since other matter has been fixed on first, but if I could come.
First, my lord,
Prayer
first,
of
yes.
the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 1st May 2024. Paragraph, case diary be produced on the agenda.
Obliged.
Grateful, my lord.
69.
69 and 71.
69 and 71.
For next week, yes, sir.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 2nd May.
Saving can bring for next circuit, your Lordship.
Next circuit.
Lordship.
Omlan. 70. On prayer of the petitioner, the matter be placed before the next available circuit bench.
Your Lordship.
71 is same as 69. 71 same as 69.
My lord,
72.
72 and 73, my lord, pertains to the same, my lord.
They are
case, right, my
together.
lord.
Yes, they are analogs.
Your Lordship, I am on behalf of the petitioner in
Yes.
item number 72. Your Lordship, kindly give 5-minute passover because my senior is in the
Passed over.
room number.
Passed over.
Grateful.
74, I am appearing for the state, your Lord.
Petitioner.
I am
74.
appearing on behalf of the my lord private response.
What about the petitioner?
No, my lord, Mr. Devjit Kundu.
Passed over.
My lord, passed over matters are taken up after.
Second.
My lord, may kindly fix the date on next Sunday.
Next, some Monday.
Next Monday.
Not Monday, Tuesday. Monday.
Let it be passed over. Let the petitioner come. Let me see whether he is interested at all.
Very interesting point of law involved.
The petitioner should be interested, isn't it?
Yes.
Okay. Yes.
In that interesting point.
Yes.
Let's see. Passed over. 77.
77, I'm paying for next week, Lordship. My senior will be appearing
Next
In this
week.
matter, let's take it.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear on the same heading on 2nd May.
My lord, in this matter, I'm appealing for the petitioner, Lordship. Can it be taken up on Monday? I'm not so much.
78. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 29th April 2024. Monday.
79. Lord, we give you for the petitioner, Lord.
Lordship,
And there is a direction to communicate the opposite party through the local police station, not I.
Has that been done?
I'm appearing on behalf of the private respondent and
Oh, he's appearing.
copy number 2.
State?
State. He's on his legs.
Hopefully, subject lordship kind
Not
concern.
necessary.
Hopefully not, because this is essentially arising out of a not seeking contractual liability. But I would be beseeching your lordship Lord, to take the last order passed by Honorable Justice Khan. First order, at the time of admission of the divisional application. If Mr. Ganguly has seen the order, Lord, I have made up my case, and Honorable Justice Khan was kind enough to record the judgments of the Honorable Supreme Court and finding of this.
13th March order.
Yes, sir. First order, no, at the time of admission. No?
That's 13th March.
Yes. Which number? Order passed by the solicitor.
It's only for outstanding dues.
Yes, may I just, would kindly take page 20.
Give me a minute. They have been disposed of.
Blood, since blood, the
Have you
opposite
seen
party
the
was
order?
not there, blood.
No, Lordship, because just now the brief has been handed over to me.
But now, blood, may I just indicate, blood?
Probably this is a case and counter case.
Case and counter case.
So that is a more a reason blood, that this application should be allowed. The Lordship would kindly take the FR forward at page 23 of my application.
I mean, this court cannot hold anything further. Everything has been held in this order. Please go
So
through the
that
order.
is the reason
Have
that
to
I
go
have
through it.
pointed out.
Only
Blood,
it's-
Just now the case has been, brief has
It's
been handed
simply
over.
bereft of one line that it is allowed. Otherwise, everything is recorded.
Well, I thought that I'll be relying on 2 more judgments, blood, taking cue from blood the Vajan law. And blood, since blood the civil liability has been brought into the blood criminal code only for the purpose of realizing the money. And I've annexed all the documents, including the agreement, which will be up. Complaint is at page 23. Kindly take note of the complaint for a moment. It's very much crystal clear that it is essentially a money claim, and he used the word, out of which he paid approximately 72,70,000. Now the outstanding amount is rupees 32,30,000.
Yes.
Lord, I reserve my right, Lord. So, Lord, it was his obligation to complete the terms of the agreement. I am the landlord. I have given it to him for developing the property. I had to pay to construct my house. Your Lordship would kindly take page 24 is the agreement. The agreement is dated 13th day of December 2020.
Yes.
Now, Lord, the first part, Lord, is the ABC in Civil Engineering and Agricultural Construction Company, who is the Lord complainant before your Lordship. And then your Lordship would kindly take, Lord, the description of the land. Your Lordship would kindly skip over those pages. The next is, Lord, the terms which is to be constructed, and the rates are there.
Yes.
And page 29 is the ultimate, the mode of payment which has been arrived by and between the parties. Now I complain about the non-supply of blood up to the mark material and non-completion of the work in accordance with the agreement. Blood, that has pinched him, and that is the reason, blood, he had to
The legal notice also says specific performance of contract.
obliged. And even
Page
if blood,
30.
I say I am entitled to get
Yes.
damage from.
I've just now received the brief.
Oh, you need some time.
Yes,
Tomorrow-
Lordship, because we give you answer because
Tomorrow-
just now the brief has been handed over.
Tomorrow.
So there is election in Darjeeling, so I may not be.
No, but that's the reason.
Oh, you're
that I
in
said-
Darjeeling. Fine.
Can-
Monday.
Monday.
But again, I have to assist your Lordship to Lordship.
No difficulty. It's not a very difficult case.
As a Lordship, but hopefully, blood, I have been able to make out the
And
case.
I
but
don't
that's
think
the-
you have further because the court has assisted you.
Obliged.
I have to go through that order again because.
Please go through this order. That will shorten your submission, I think.
That has helped the petitioner to come over, blood, with the.
All the observations have been made in favor
Including
of the
the judgment-
petitioner.
including the
The
judgment.
judgments have been discussed. It is only one line is not there in the order that the application is allowed.
In absence of the state and blood, the opposite
Yes.
party, hopefully that could not be.
Please go through this order. That will help us dispose of the matter. Yes.
Obliged. I'll send you the order. I'll send both of you.
On
George.
prayer of the, you're the state or the private?
No, private.
On prayer of the private opposite party, the matter is urgent. Very good. Let the matter Monday.
State is Monday.
Let the matter appear under the same heading on 29th April 2020.
Now let Mr. Chakraborty not be deprived. State is present, otherwise he'll be deprived.
Yes, I'll, yes, the names will be recorded.
Of license.
And please come prepared. So it's a short matter, you can dispose it.
Partner.
Matter
Yes.
is hard.
Partner matter.
Let it
Monday, what do you mean by partner?
হবে না, read হবে না। না, হবে। আছে।
Passed over.
Lordship, I am for the petitioner.
Yes.
And this petition has been filed before your lordship for quashing.
Have you served?
No, this is for the first.
Appearing for the first time, yes.
The
Filing.
147.
Yes.
The gist of the complaint is that the victim lady was 23 years old and the petitioner is 20 years old. They had relation for a period of 2 years prior to lodgement of this FIR. And at the time of FIR, the lady was 9 months pregnant, as it reveals from the FIR. Now, this victim's statement has been recorded under section 164 CRPC. And also,
charge sheet has been submitted.
Yes, charge sheet submitted, and thereafter on the very date, the cognizance taken and thereafter committed to and thereafter transferred to MAL additional district and session judge. And case is pending there. Now, from the 164 and from the deposition, from the statement under section 161, nothing has revealed, save and except a line.
Where are the documents?
Documents
in the envelopes?
Yes, yes. Your Lordship.
এটা বের করে দিন তো বিশু, যে এর মধ্যে ডকুমেন্ট গুলো আছে এনভেলপ
P1
সবগুলো বের করে Yes, P1, the complaint.
P1, this page 15 FIR. No, 12. And 13 is formal FIR. 14 is the charge sheet. And this.
Yes.
And 17 is the statement of the victim lady under section 161.
Yes.
Only 2 lines, stereotype lines are there. He used to come to my house and had physical relations several times with me with a promise to marry.
Proceeding will be stayed. Please serve notice.
Yes.
These are very common cases of 417 and 376. Promise to marry. her learned counsel for the petition. The petitioner has prayed for quashing of Sessions case number 35 of 2024, arising out of GR case number 5380 of 2023 under section 417/376 within bracket 2 of the Indian Penal Code. Paragraph. The Indian Penal Code on the ground, on the ground that the de facto complainant of the case was in a consensual relationship with the petitioner for considerable period of time, and there is no element under section 417/376 within bracket 2 of the code herein. Paragraph. It appears from there's a 164 also.
Yes.
Where is it?
Yeah, 164 in page number.
It appears from the statement of the de facto complainant / victim under section 161 of the code, 161 as well as section 164 of the code. It's in Hindi.
Yes. I may
that
25, 26
yes, that the
page.
relationship between the petitioner and herself was consensual the only allegation of the victim is that the petitioner was involved in physical relationship with her upon promise to marry her, but subsequently did not keep up to the same. Paragraph. Upon consideration of the material available on record, comma, this court is inclined to hold that the petitioner has been able to make out an arguable case. Paragraph. The petitioner is directed to serve notice upon the opposite parties, serve copy of the application upon the along with annexure thereto upon the opposite parties, and file affidavit of service on the adjourned date. Paragraph. Yes.
As the private respondent is not no address name is given, so I may pray for service through the concerned police station.
Very well. On prayer of the petitioner, comma, liberty is granted to serve the second opposite party through the concerned police station. Paragraph. All further proceedings of Sessions case number 35 of 2024 arising out of GR case number 5380 of 2023 at 11 pending before the learned additional sessions judge at Malbazar is stayed till 31st May 2024.
Yes. Grateful.
The matter be placed before the next available circuit bench. 82 passed over.
My lord,
হয়ে আছে।
proceeds with the list, my
Let's
lord.
just call the passed over matters, right?
My lord, I'm seeking your lordship's leave before your lordship proceeds with the list, my lord. My lord, proceeding pending before the DLRO, my lord, is under challenge.
Are you mentioning?
Yes, my lord.
This
Yes,
is not the mentioning time.
my lord. If
10:30 tomorrow.
yes.
Item number 7, passed over matters.
Yes, item number 7. देखिए. None appears for the petitioner. No accommodation is sought. The matter be placed before the next available circuit bench.
Item number 10.
I'm for the petitioner, Lordship. Yesterday I have bring my brief, but somehow missed from the court, Lordship. Kindly keep it to next circuit because I'm not getting the brief.
Okay. On prayer of the petitioner, the matter be placed before the next available circuit bench.
Item number 14.
File देखिए. The dismiss for default হয়ে আছে. CU 88. Can 1 of 2022. কোথায় application? None appears for the petitioner. No accommodation is sought. The matter be placed before the next available circuit bench. Can you go? No. Next.
Item number 15.
File. Same one as it is for default. None appears for the petitioner. No accommodation is sought. Paragraph, let the matter be placed before the next available circuit bench.
Item 16.
Same order. Next circuit. Same order. Thirty-one. 31. Yes.
Lordship, I'm for the petitioner, applicant. This is an application under section
Who is
482.
appealing for the second opposite party? You are appealing?
I have paid for quashing of the complaint case. By number 2 of 2021, it was initiated under section 447, 379, 323, 427, 506, and 34. Now it is pending before the Judicial Manager First Court, Shodor Kuchbiar. Lordship, the case in a nutshell is that a complaint was lodged by one society. The complainant is that
The second opposite party.
second opposite, Kuchbihar Dharma Sabha,
Yes.
they have lodged one complaint inter alia stating that on a particular day and time, the revisionist 1, 2, and 3, along with their men, went to forcefully open a shop which belonged to the second opposite party. And by doing so, we were restrained and they abused them with fist and blows and such and such. Lordship kindly sees, first of all, before I go to the niceties of the case, I take your Lordship to page 50, that is annexure P13.
Yes.
Order dated 6 January 2021. The Kuchbihar Dharma Sabha Sajjan filed a complaint under section cognizance is taken. It was transferred to JM Fast Court for doing the necessary things. And 17 to 2021 was for fixed for examination of essay. Now, Lordship, kindly comes to the certified copies I have furnished. Got it, Lordship?
Yes.
Lordship kindly sees order dated 17 to 2021.
Yes.
It was adjourned and the date was fixed on 25 to 2021. Kindly Lordship sees that after the complainant was examined under section 200 CRPC and discharged, the complainant himself, and certain documents were filed, wherein it was found that civil case is pending between the parties. And second para, the IC Kotwali PS is directed to hold investigation personally or may depute any fit officer under him to do so. A copy of the complaint is sent. 202. Now, Lordship, the continued representation part, the SP was sent with the copy, and on the next date, today the date is fixed for report under 202 CRPC from Kotwali PS, Hajira file, so and so. Passing order was 29/4/2022. The report was submitted. Now, kindly Lordship, after the order number 10, that is order dated 29/4/2022, last line. Now, here Lordship will see certain things here.
Yes.
Lordship. Lordship, firstly sees the report. The last page I have filed the report. Report of SI Shogoto Dash.
Yes.
Dated 25 January 2022. May I read the report, Lordship? Inquiry report 1 and 2. In context with the above, I have the honor to report before your learned court that as per kind endorsement of IC Kotwali PS, I have caused an inquiry into the matter of Kuchbihar Dharma Sabha versus Abhijit Dash and others, and on examination of local witnesses. Now, this is very vital, Lordship. I pray before Lordship to kindly note the word on examination of local witnesses and name of the witnesses. Ashish Shaha, son of such and such, to Porimal Chandra De, son of such and such, and Probit Dash, such and such, and Dilip Kumar Shaha. These four purportedly the local witnesses who witnessed this thing and to and gave their statement to the investigating officer. Basing upon their statement, the report has been submitted. Now, Lordship kindly says, Dilip Shah, Sajasar, Nehru Nagar, Kochbiar, and it could be learned that alleged person Shankar Guha Majumdar was the tenant of a stall of Kochbiar Dharma Sabha from 7/4/2015, but he did not running any business and closed the stall. He also not paid the monthly rent properly to the Kochbiar Dharma Sabha. On this ground and as per decision of other members of Kochbiar Dharma Sabha, the said person has been noticed to evict the premises, but he did not pay any heat. Moreover, he sent intimation to Kochbiar Dharma Sabha that he would hand over the said premises to one Abhijit Das for running business. After that, when the said Abhijit Das tried to open the stall, then the members of Kochbiar Dharma Sabha raised objection. Thereafter, the Kochbiar Dharma Sabha filed title suit before Civil Judge Junior Division Kochbiar for eviction of their tenant Shankar Guha Majumdar. On 19/12/2021, this date is relevant, Lordship, Abhijit Das, son of Noni Gopal Das, Kochbiar, along with Shankar Guha Majumdar, son of Amal Guha Majumdar, and other. So here two names are there. One is Abhijit Das and another is Shankar Guha Majumdar. Before petitioner, the Abhijit Das is the petition number 1 and Shankar Guha Majumdar is petition number 2. No reference of the petition number 3 here. But in the complaint, I'll show your Lordship that his name is there. The name of third petition is also there. Now, came to Kochbiar Dharma Sabha and tried to open the shutter of the tea stall and when the members of Kochbiar Dharma Sabha raised objection, then a hot altercation and shouldering was taken place, and after that the alleged person forcibly entered into the stall by breaking open the lock of the closed shutter. So, after inquiring 4 local witnesses, the police found that out of 3 petitioners, 2 petitioners went there, tried to open, shouldering took place, hot altercation took place, and forcefully they opened the stall. This is the report of the police. Now, once again, before I go to the complaint, Lordship will see that the sections are 447, 379, 323, 427, 506, 34. So at a straight drive, if I can say, 379 goes away from this report. Second is that the 4 names which I have stated purported to be members of local community who has narrated the incident to police. Now, Lordship, I will just explain who are the local communities. Copy को सर please be with me. क्या तो बेटा मतलब तो ना मचा अभी নামগুলো নামগুলো একই না
Yes.
Lordship, 1 second. Actually, this is a change brief. So I'm getting a little. Thank you, Munish. Lordship. Kindly see page 19, P2 of my petition.
Yes.
This is not the.
This is for alternative accommodation.
Lordship, I may start my way.
Do you want to come prepared on Monday?
That would be better.
Because he's finding it difficult. Mr. Ahmed is here for the
I
weekend.
know, but my learned friend was saying there are 4 persons, 2 of them allegedly are the members.
Lordship, kindly.
That's what he want to
No.
at
All
page-
4.
Oh.
Page 28. Page 28 though. P7. Kindly see, Lordship, left are the members of Kuchbihar Dharma Sabha. Got it, Lordship?
Page
28, P7. P7. This is a document issued by the Kuchbihar Dharma Sabha, wherein it was addressed to Shankar Guha Majumdar, that is one of the revision. What is the content? We, the landlord of Dharma Sabha, BS Road, Kuchbihar, agree to hand over the tenanted premises today on 19/9/2016 to Sri Shankar Guha Majumdar, proprietor, Electrical, BS Road, Kuchbihar. Thanking faithfully. Now, on the left side are the office bearers and dignitaries. Kindly see Saho Sampadak, second one, Ashish Saha. And please tally with the report of the police. Local witnesses, namely one, last page, Lordship. Last page. Fourth line from top. Local witnesses, namely Ashish Saha.
Yes.
Now, Ashish Saha we have got, he is the Saho Sampadak, Assistant Secretary. Now, next, Lordship, we'll find Karjokari Sodosho, number 3, Porimal De.
Yes.
In report, he is number 2, purported to be local witness. Then, Lordship, Karjokari Sodosho number 2, Probir Das.
He is also.
He is also number 3. And the fourth one is Karjokari Sodosho, third from bottom, Dilip Saha.
Yes.
So the police conducted inquiry solely having person interested in the property, not from the local witnesses, but did not mention in the report that I only conducted inquiry from the persons of Dharma Sabha. Here it was from the local witnesses, as if the truth has come forward. Lordship knows better than me. The proviso of this the procedure of 202 CRPC. When magistrate has certain doubts after going through the documents and solemn affirmation regarding the genuinity, so he orders the police to pause a inquiry and give the report. Here, what we find here, not only the date mentioning the incident happened on 19/12/2021 is wrong, but also no proper inquiry was conducted by the police. Only by the help of the person having interested and party to the suit, the report has been filed by the police. This is my first submission, Lordship. Now, Lordship sees I have filed a certificate copy of the petition of complaint. Backside, Lordship. just prior to that report, police report.
Yes.
Yes. Lordship sees the date, গত 19/12/20. The incident happened on 19/12/20. Police report 19/12/21. Now, কুচবিহার ধর্মসভা বলপূর্বক অনধিকার প্রবেশে ধর্মসভা সংলগ্ন মালিকানাধীন একটি স্টলের অথবা শাটার বন্ধ তালা ভাঙিয়া প্রবেশের চেষ্টা। Here, exaggeration of lordship will find দায়িত্বে প্রত্যেক সদস্যের নামে অকথ্য অশ্লীল ভাষা গালিগালাজ করেন, ধর্ম চলতে থাকা উৎসবের সাজসজ্জা হোর্ডিং ভাঙচুর করেন এবং ধর্মসভার ভেতরে থাকা ফুলের টব বেশ কিছু ঔষধ আয়ুর্বেদিক গুচ্ছাদি গাছ আত্মসাৎ করেন। So, for breaking the hoardings, 427 mischief is there. For আত্মসাৎ of those Ayurvedic oshudhs, 379 was there. And অশ্লীল গালাগালি 506 was there. The police under 202 submitted report inquiring with this same person, but did not say anything regarding all three ingredients. No bhangchur, no attoshat, no galagali. Then the thing is, সভাপতির কলার চাপিয়ে ধরেন এবং তাকে কিল চর ঘুষি মারে এবং ধাক্কা মারিয়া মাটিতে ফেলিয়ে দেন in complaint. But the police report is shouldering. So exaggeration was there. It is. So now we come to 323 only. Whether the petitioners here actually went on that very day to, as alleged, to open the shop and while protested, any shouldering took place or not. The rest of the sections, Lordship has seen, the police report does not support. Now, please allow me to come to my petition.
Yes.
To understand this case, Lordship, we have to go back long before. What prompted this Dharma Sabha to file this fabulous complaint, and why did they do so? Regarding that injunction, and I'll come to later, that was refused, and the case has been decided in our favor. Para 3.
Yes.
It is admitted that since 1973, the applicant number 2 was running this stall out there. Kindly see page 15 to 18, annexure P1, 15 to 18, Lordship. 15 is the affidavit executed on 73, Lordship. So 20 years document.
Yes.
This was between Shankar Guru Majumdar. He issued the affidavit. That is Shankar Guru Majumdar is the petition number 2. Then on 1st Boishak 1380 BS corresponding to 14th April 1973, I have started a business for dealing electrical goods at Vishwa Singh Road, Kuchbihar town, PS Kotwali district, Kuchbihar, under the name and style Electrocell. Have given it. Lordship, the affidavit I have 15A is the copy.
Yes.
Typed copy. Then Lordship 16. That I have given government West Bengal cell tax, Electrocell, Kuchbihar.
Yes.
This was of 85, Lordship. Then Kuchbihar municipality license in my name, Electrocell, 13886. Rent. Then Lordship files Kuchbihar Dharma Sabha.
Is this in dispute? I don't think so.
No. Now, what they are saying that I did not run any business, and as such, I did not pay any rent, and they have closed my door. And while trying to open the same, this dispute cropped up. Lordship, then Lordship kindly sees. So apparently, since 73, the petitioner number 2, Shankar Guha Majumdar, was running business and on that shop. Now, kindly sees Lordship, page 19. Page 19. Page 19, P2.
Yes.
This is the Secretary, Kuchbihar Dharma Sabha, issued on 1/4/2011. Kindly sees the contents. Dear sir, Kuchbihar Dharma Sabha has taken up development work to renovate the position of area, and in that end, in view, has taken up the proposal of the structure standing in front of Dharma Sabha along Bishwasingh Road. The project was taken to raise 4-storied building wherein the existing occupiers, this is relevant, Lordship, the existing occupiers will be provided to their respecting positions subject to diminish of space to some extent. So the Kuchbihar Dharma Sabha, after demolition of the old structure, they gave a proposal of building a 4-storied building where the existing occupiers will be given position subject to diminishing of space to some extent. So till 2011, this is the reason I am showing it, Dharma Sabha gave the proposal to me. So I was in possession running the shop, and Dharma Sabha, as per this letter, that after the construction work, Dharma Sabha will grant me my space in the 4 stories building allotted. Now, kindly Lordship, in para 6, I have mentioned that written agreement in view of the proposal, but they said requests were not. We have told that you should there should be a written agreement between us.
That was not done.
That was not done, but the said requests were not heeded. As a result, applicant number 2 did not agree with the proposal dated 1/4/2011. The proposal I have just shown, Lordship. The consequence for not agreeing upon such proposal was refusal of accepting rent from the applicant. Number 2, because Kuchbihar Dharma Sabha rejected to accept the rent for the period of June to August 2011. So, as because I did not agree to this annexure P2, page 19, their proposal, and told them to please come to an agreement so that we can bring the terms in black and white. They did not, and they stopped taking rent from us. Now, what happened? For non-acceptance of the rent, kindly sees page 20, Lordship. I went to before the learned rent controller, and this is the order of the rent controller. So the police report, once again, I come back to the police report, Lordship, where the Dharma Sabha person purporting to be the local witnesses has narrated to the police that no rent was paid by me till this 2011, when the proposal was not accepted by me and an agreement proposal was given, they stopped taking the rent. I went to the rent controller. So I was paying rent altogether since then. Then, Lordship, kindly sees. Then, page 20, yes. Kuchbihar Dharma Sabha, then para 8 of my petition, Lordship. In order to illegally remove the applicant number 2 from its stall, the Kuchbihar Dharma Sabha started demolition of the stall in the year 2014. The applicant number 2 brought this issue to the notice of subdivisional officer Kuchbihar Sodor by its letter dated 22nd 9 2014 and requested to take appropriate steps to the safeguard of the interest of applicant number 2. Page 21, Lordship. They forcefully tried to demolish the structure. I was paying rent to the before the rent controller. I took refuge before the SDO Sodor Kuchbihar, stating that this is the fact. The application received on 22nd, Lordship, kindly, it says upside down, 22nd September 2014, below, Lordship, below the receipt signature. Yes, yes. So it was received by the SDO. Now SDO also stepped into the facts. Para 9 of my petition, Lordship. It is to the intervention of the SDO subdivisional officer Kuchbihar Sodor, an agreement was executed between the applicant number 2 and Kuchbihar Dharma Sabha. So SDO told no, you have to execute an agreement. And Lordship, it was done. The agreement was executed, Lordship. For the concept, it was decided that Lordship sees page 5 of my petition, the certain terms and conditions of the agreement. 22.
The payment part.
Payment part. And Lordship sees page 22, that is annexure P5, is the Bharatiya Chukti Patro. Because we were in the doubt that once we leave the shop room, if we are not allowed to re-enter, so we cannot do anything. So this is what tripartite agreement between the landlord and tenant, and in presence of SDO, Lordship. Kindly see, it was decided on Lordship, the page 24, উপস্থিত সাক্ষীগণ, সদর subdivisional officer সদর কুচবিহার on 7th April 2015. Now, Lordship. So in the agreement, Lordship will find these terms and conditions which I have mentioned in my paragraph 9. Your Lordship will find. Now, kindly see His Lordship, page number 23, paragraph number 1, 2, 3, 4, 5, 6, 7, 8 from top. Now, one allegation, Lordship, prior Lordship says, one allegation is that the police report is being said that I did not pay any rent, that has been curtailed. Now, on contrary, I was trying to hand over sell the shop to another person. Name is there. Now, this paragraph. যদি কোনো দ্বিতীয় পক্ষ ও তার নিজের ভাড়া ঘরটি অন্য কোনো হিন্দু ব্যক্তিকে ব্যবসা চালাইবার জন্য হস্তান্তর করিতে চান, সেক্ষেত্রে উক্ত দ্বিতীয় পক্ষ দ্বারা নিযুক্ত বা হস্তান্তরিত নতুন ব্যক্তিটি ভাড়াটিয়া হিসেবে পরিগণিত হইবেন এবং নবনিযুক্ত হস্তান্তরিত ভাড়াটিয়ার সমস্ত শর্ত পালন করিয়া চলিবেন এবং হস্তান্তর থাকাকালীন তিনি কুচবিহার ধর্মসভা কমিটিকে 2 লক্ষ টাকা ডেভেলপমেন্ট ফি বাবদ সেলামি হিসেবে প্রদান করিবেন। এই নবনিযুক্ত অথবা হস্তান্তরিত ভাড়াটিয়া চয়নের ক্ষেত্রে দ্বিতীয় পক্ষের একক এবং অবিসংবাদিত অধিকার থাকিবে, শুধু দ্বিতীয় পক্ষ প্রথম পক্ষকে হস্তান্তরের ব্যাপারে অবগত করিবেন। Who is the দ্বিতীয় পক্ষ, Lordship? Page 22. It's me, Shankar Guho Mujumdar. So the right of choosing a person, the transfer, is the sole discretion of Shankar Guho Mujumdar, not Kuchbihar Dharma Sabha. What I have to do as per the agreement? শুধু দ্বিতীয় পক্ষ প্রথম পক্ষকে হস্তান্তরের ব্যাপারে অবগত করিবেন। This agreement was between Kuchbihar Dharma Sabha and Shankar Guho Mujumdar, the then tenant. Now, Lordship, page 25 onwards, Lordship will find page 25 that Shankar Guha Majumdar, the amount, Lordship, 50,000, then 45,000, 10,000.
Yes.
This is as per the agreement. Lordship will find in my page 5 of my petition, and also as per the agreement, page 23, প্রথম কিস্তিতে 50,000. Those payments were already made. দ্বিতীয় ক্ষেত্রে কিস্তিতে 55,000. Got it, Lordship?
Yes.
So we already paid those things. Now,
The payments are not in dispute.
no. So what I am trying to show, Lordship, that each and every allegation what has been brought by them against us do not support their case. Page 27, Lordship, annexure P6.
Yes.
This is a letter given to Honorable Subdivisional Officer once again, which was received, endorsement is there. Can you see, Lordship? Lay down the said agreement, but my landlord failed to hand over the tenanted room to me within stipulated time, that is 6/4/2016. After I paid the money, the construction was done, but the shop was not handed over to me. So once again, the intervention of the SDO was sought. Because, Lordship, in page 23, the fourth paragraph, it is mentioned, অত্র চুক্তিপক্ষে দ্বিতীয় সম্মত স্বাক্ষরিত হইবার পর এবং আগামী 1 বছরের মধ্যে উল্লেখিত কিস্তির টাকা ক্রমান্বয়ে দ্বিতীয় পক্ষ প্রথম পক্ষকে দিতে বাধ্য থাকিবেন, হুইচ আই পেড। বিনিময়ে প্রথম পক্ষ দোকান ঘরটি নির্মাণ কার্য দ্রুত সম্পন্ন করে আগামী 1 বছরের মধ্যে নবনির্মিত ঘরটি দ্বিতীয় পক্ষকে প্রদান করিতে বাধ্য থাকিবেন। As because I have complied my part, paid the amount, but they did not hand over the said, so intervention of the SDO was once again sought for. Page 31. Now, Lordship, kindly sees page 28. Once again, that document I have shown at the first, where the name of the local witnesses are there to be office bearers. Now, this is the handing over document.
Yes.
The new shop room was handed over to me. Now, Lordship, page 29. I have duly intimated the same to SDO also, because after only because of his intervention, the shop, I could get back my shop. So I have intimated the said to the SDO also. This is page 29, Lordship. And page 30 is the rent receipt of 19/9/2016.
Yes.
For 9 months. Altogether 9 months. Now, as per the agreement, Lordship, if I decide to hand over the shop to any person, it's my discretion. He has to be a Hindu, and I have to intimate. Only I have to. My role was to intimate Dharma Sabha. Kindly see page 31. Secretary Kujbehar Dharma Sabha on 10/7/2020.
Yes.
The intimation was handed over by Shankar Guha Majumdar.
Yes.
This 31, then Lordship 32, the postal receipts. Once again, page 34 up to 35, Lordship will find.
Yes.
31 to 35. So I have intimated. Now, Lordship, Obhijit Dash, that is, now Lordship, page 36 is relevant. That is letter intimating taking over this stall by Avijit Das. He took the stall.
Yes.
That is petition number 1. Now, Lordship says 21st July 2020.
Yes.
Now, page 37 is very important, Lordship. 4/11/2020. This is a complaint made by said Avijit Das, that is the new person to whom I have handed over the shop, to the Kotwali IC. Date is very relevant, Lordship, 4/11/2020. Kindly sees last but one para, last but 1, 2, 3, 4, fourth para. Today morning, 10 a.m., when I went to open the stall, I found that some miscreants have blocked the shutter lock by welding the same in with iron strip. Photograph of the said mischievous act is attached herewith for ready reference. That is emergent situation. I am to inform the matter to you for favor of your kind information as a reaction. Now, the next part is very relevant. That I am to run my business in this stall, and due to the mischief, I am to open this stall by breaking the mischievous obstacle. So on 4/11/2020, after giving intimation to the police, said Avijit Das, he broke open the welding and entered into his shop. Now, once again, if okay, Lordship sees page 38, that welding photograph is there.
Yes.
Welding photograph. So, as per the complaint and the police report, that on 19/12/2020, when they have locked the shop, we were trying to open it and the dispute cropped up. But here, 4/11/2020, when actually they have welded my shutter, said Avijit Das, he, after intimating to the police, cut open the welding and took and entered the shop. So no question arose subsequently on 19/12/2020. Why this complaint was lodged? As because FIR was given to file one eviction suit. I'm coming to that, so that injunction is obtained, and it was obtained. Subsequently, we entered, we showed the document, and court opined, no, I was in possession since long, injunction vacated. Now, page number 39. Avijit Das has given a letter to the Secretary President Kujbehar Dharmashala, letter seeking rent receipt and removal of hoarding. Now, when they failed to obstruct said Avijit Das from entering into his shop, what they did, they put one hoarding in front of the shop. Now, kindly see page para 2. On the of the term of agreement, I have duly paid the rent for below mentioned stall to you, and the rent is paid up to date. That is, this is 5/11/2020. But you have not issued rent receipt to me. Hence, I am entitled to get the rent receipt for the month July 2020, August 2020, September 2020, and October 2020. Now, that you have put a hoarding for schedule of Durga Puja in front of my tenanted stall, and as Durga Puja is over, you are to remove the hoarding which you have yet not done. Now by this letter, I urge you to issue the rent receipt of the said stall in my favor for the month of July 2020, August 2020, September 2020. So once again, the allegation for dispute cropped up for not paying the rent. On the contrary, I have given this letter to the Dharma Sabha. Kindly see page 40. That is the money order and the receipt. July, August. July and August. Page 41 is the August, which I have already paid.
Yes.
Now, India Post, Lordship will find that letters were delivered to them, but they did not do anything. Kindly see page 43 to 45. The transaction, bank details, State Bank of India. I have duly January, December paid to Kujbeh Dharma Sabha. Those are there. Then November, October. On the next page 44, November and October. Transfer to Kujbeh Dharma Sabha. I have duly paid the rent. Now Kujbeh Dharma Sabha filed one eviction suit, page 46. Now relevant portion is page 48, middle portion, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 14th line.
From top?
From top, Lordship. Fulfill, and it can also be found that the possession of the suit premises has already been given to defendant number 2, for which he has tenanted rent month by month. It was the observation of the court. The suit was filed by them, the observation of the court. And from below, from bottom, Lordship, 1, 2, 3, 4, 5, 6, 7th line, it appears that defendant number 2 is in possession of the suit premises. The apprehension of plaintiff regarding causing any damage to the suit premises also cannot be brushed aside. So at this stage, possession party so and so, so and so. So my possession since long has been established in their suit. Now Lordship sees they have filed the case on 6 January 2021, stating that on 19/12/2020, we tried to break open the shop and entered the same. Where the Lordship has seen from the document, after intimation to the police on November, when they have welded the shutter, after giving intimation to the police, I have removed the obstruction and took possession of the shop. So now I sum up saying that the petition of complaint which has been filed here, stating certain facts, the date is highly improbable, as because since November 1 day when they have obstructed, I removed the obstruction and I entered and doing business. So on 19/12/2020, no obstruction was created by the Kujbeh Dharma Sabha, and as such, there is no probability of me trying to remove the same and entering into my shop. Second is stating that dhakka, kil, chor, ghushi, ittadi. Now, Lordship, when no incident of 19/12/2020 could be established, and by the police report only shouldering between both the parties, the police report. So kill, chor, ghushi, matite fele mara, nothing is there. And what I say that 19/12/2020 no incident is there. So because that time I was already, Abhijit Das was already within his domain, and Lordship, this is most relevant. Abhijit Das removed the obstacle after informing to the police. So from this fact, Your Honor, Your Lordship can certainly take note of the same, that he is a law-abiding citizen. Petition number 2, Shankar Guha Majumdar, who has taken the shop on rent on 1973, obviously is an aged person, senior citizen. So this allegation of kill, chor, ghushi, fist and blows by a senior citizen does not make any sense. More so, Lordship, in the civil suit, the said complainant, during his examination, I will file the same under I'll make a I'm not handing over the same. I'm just reading it. I'll hand over this because now he has got this. He has been. It is a fact that Abhijit Das and Shankar Guha Majumdar never broke lock and key of this suit premises.
Whose evidence is this?
The complainant of this CR case in the eviction suit lodged by them. His deposition. না এটা দিয়ে দেবো আমি করে দেবো
Please file a
supplementary
supplementary
affidavit,
affidavit.
I'll file it. Just now he has brought it from Kuchbihar. So, Lordship, from the facts and circumstances, from the allegation leveled in the petition of complaint, and yes, obviously, sir, you are obviously, and from the documents placed by me since 1973 to till date, the allegation of the date of incident, no such incident occurred. The allegation of Kilchor Ghushi, fist and blows, removed by the police, saying that it was soldering between the parties only. The allegation of theft not supported by the police, and breaking of damaging of hoarding not supported by the police, and more so, the police report itself is bad as because without doing any proper inquiry and doing inquiry only his investigation inquiry domain was within the purview of the Kuchbihar Dharma Sabha members, which did not reveal the truth, but they also did not support the case of Kuchbihar Dharma Sabha.
Yes.
So my humble submission, Lordship, this petition of complaint which has been filed by Kuchbihar Dharma Sabha may be quashed, and keeping in view that since inception, since the date the old structure was removed and the building was constructed, each and every point Kuchbihar Dharma Sabha did not cooperate, and I had to take the refuge of SDO and the police. So their anger, their cannot be brushed aside, and to fulfill their the eviction suit, they have lost this petition, Lordship. This is my submission.
Will you come back tomorrow with a supplementary affidavit?
Lordship.
Tomorrow?
Lordship.
You are here? No.
I'm not here, but I'll be just taking one, I'll just check 5 minutes of the Lordship's time. But it is advocate position that we are not denying this. We are in a proceedings where the offense under section 379, 447, 427, 5 is a 679. Now, whatever my learned friend is saying, but your Lordship will examine under section 480 disputed question of factor. The law is well settled and well clear. That the plethora of judgment says that this disputed question of facts cannot be looked into while exercising jurisdiction. But I'll just take recourse of section 404. Subjective satisfaction of the government magistrate is of the prime of the case laid out for proceeding in the trial. Nothing more, nothing. What my learned friend has pointed out about the examination of the 4 witnesses, that they are previously member of the Dharma Sabha, that does not brush aside the incident. The investigative court was initially satisfied and court was aware about the fact the Lordship of the initial order of 17 to 2022, when the learned magistrate has taken up the application, and after initial interpretation, the learned magistrate came to a finding that an independent inquiry by the court is required. It was not that the complainant has only came up with this witness and it was before the court, and thereafter the learned court issued process. The learned court was of the opinion that to harass, verify, and to come to examine the veracity of the complaint, the learned court was kind enough to pass an order directing the local police to cause an inquiry. The inquiry report reveals that there is an incident, which my learned friend has also corroborated. The inquiry conducted by the investigating agency may be a member of the, or previously they were member, because my learned friend is showing a document of 2016. The incident is of 2020. We never deny that he is not a head. Neither Abhijit, neither the previous. There is an order passed by the learned court, thereby directing to maintain status quo in respect of the supervisor.
In the eviction suit.
Yes. Now, whether that has been violated or not, whether the incident of the shouldering includes many things, but that will come only in course of trial. It's not that at this stage, while deciding the application under section 482, the lordship is kind sanction to see the initial deposition which is lacking in the additional application. The learned magistrate's satisfaction with regard to issuance of processes not only solely based on the report of the police, though the police report indicates the prima facie case. So it is not his case that the incident has never happened. If he says so, he will be disputing the fact. Now that disputed question of fact, the lordship cannot assess at the time of quashing of the application. But in support of my contention, Lord, I have two judgments where he has been specifically contended by the Honorable Apex Court that the court should not exercise jurisdiction when there is a disputed question of fact. It is obvious that the petitioner before your lordship as well as the members of Dharma Sabha, they are people of the locality. It is not his case that the incident has not happened. We cannot say so because there are two clinching evidence in respect of occurrence of the incident. Now, your lordship knows 323 can be occurred by pushing also. That coming out from the inquiry report that there is a shoulder. Now, mischief 427, there is a damage. 378, whether has been made out or not, that requires not. That would be only concluded after examining the witnesses. That stage has not come. The satisfaction is only based on prima facie case to proceed. Now, this I'm harping on this phrase only because of the reason that this objective satisfaction of the learned magistrate is in this particular case is three. One, the learned magistrate can peruse the complaint and issue process. Two, the after initial deposition, the court might come to a conclusion that there is a case prior to proceed. And thirdly, the report. Now, if your lordship would kindly see the complaint, the initial deposition, and then the police report, it says that there is an incident and it was trial. Now, my learned friend has shown all the documents in respect of his tenancy right, his right to transfer the tenancy in favor of the third party. We are not disputing. We are not disputing in the context that the suit we have filed, we want to debate. The question of his locus, as stated, we have never disputed. We say that on that particular day, you have committed an offense as defined under the Indian law. Now, in support of that contention, the primary evidence we have given to the learned court. The learned court, after perusal of the documents, as I indicated, three documents, which is the complaint, initial deposition, again, police report. The learned magistrate has came to a satisfaction, and he has recorded the satisfaction why the learned magistrate has issued process. The learned magistrate initially did not do so. There is a check and balance. The learned magistrate was very much cautious in issuing the process, which would be evident from the report calling from the eyes. So, I beseech your lordship not to interfere with the disputed question of facts that can only be proved during the course of trial. Whatever his claim in respect of the tenancy right and other things, that is never disputed. And I beseech your lordship not to quash the proceedings only on that score, because there is a prima facie case. And even if there is a point of law involved, even if there is a civil suit pending in respect of a tenancy right, or there is a dispute, there is a suit pending, that also pertains to a disputed question of fact. In that case, even proceeding in criminal trial in a complaint case is not a bar. But your lordship's jurisdiction is widened enough, but still the principle of law which is governing the police is that prima facie case is made out. These are my respectful submission. I am relying on two judgments of the Honorable Supreme Court. Now, I will be giving a copy that one is reported in 2019-6 SCC page 107, particularly paragraph 9 and paragraph 11. 11 to 16. So may I just read?
Paragraphs 11 to 16.
Yes. I just read not paragraph. Paragraph 9, the first statement is that the High Court did not examine the case with the view to find out as to whether the allegations made in the complaint prior to make out the offence falling under section 23 and 379 into section 34 IPC or not. Instead, the High Court in para 6 gave importance to the fact that since there was a dispute pending between the parties in the civil court in relation to the shop as being landlord and tenant, it is essentially a civil dispute between the parties. It is on this ground the High Court proceeded to quash the complaint. This approach of the High Court is in our own view is faulty. Number 10, paragraph 10 is relied on the Bhajan law and Honorable Supreme Court relied on the Bhajan law. The High Court failed to see the mere tendency of the civil suit is not an answer to the question as to whether a case under section 320 and 379 made out under section 34 is made out in an instrument number 3 or not. The High Court should have seen that when a specific demands of the appellant in the complaint was the respondent number 20 have committed the offence punishable under section 320 and 379 created in section 34, then the question to be examined is of to whether there are allegations of commission of these two offences in the complaint or not. In other words, in order to see whether any prima facie case against the accused for taking its cognizance is made out or not, the court is only required to see the allegations made in the complaint. In the absence of any finding recorded by the High Court on this particular question, the impugned order is legally unsustainable. So I will be relying on this judgment, which is apparently not back on the point because of the there was an existing civil dispute. It also said, and as I said, the satisfaction of the court is the another one is 2009. 12 SCC 331. I am supplying a copy. The relevant paragraph is the 3 and 9.
3 and 9.
3 and 9. I just pick out the finding of the order. The High Court was justified because that was also the factual background, but I'm not doing factual background. Principle laid down if the High Court was justified in holding that disputed question of facts are involved. The application of the section 482 of the code has been right with it. Not finding a scope for interference with the order of the High Court, however, make it clear that we are not expressing this. Disputed question of facts were also there from our both side. That is appearing at character. So these are my respective submission of the point of law as well as the factual. Whatever document my law defender said, there is no just to prove these people. But these are my respective.
Well, tomorrow we'll submit the
Let him file this application.
along with the reply of these two judgments. He can.
If it requires not from here,
Or learned counsels for the parties. Paragraph, learned counsel for the petitioners seeks to use a supplementary affidavit annexing relevant documents. A learned counsel further seeks to reply to the submission made on behalf of the opposite parties. Let the matter appear under the same heading tomorrow, that is, on 26th April.
Grateful, Lordship.
Next.
Item number 33.
File the later on the None appears for the petitioner. No accommodation is sought. Paragraph, the interim order is till June. That's why no one is appearing. The matter will be placed before the next available circuit bench. None appears for the petitioner, no accommodation is sought. The matter be placed before the next 34th, you're appealing. The matter be placed before the next available circuit bench. The same one. 44, same one. Next. Unique 44, unique, same one. 45.
Forty-five.
45.
I'm for the petition. 45 totally service total complete, not completed. So
Next
I'll
circuit.
make it next circuit. 45.
On prayer of the petitioner, the matter be placed before the next available circuit bench. Petitioners. On the petitioner acting. Yes, 46.
My lord, I am for the petition. My lord.
Have you served?
Yes, ma'am.
Mr. Aditi Chakraborty is appearing. You asked for modification of the sentence.
Yes, my lord. Modification.
Mr.
My humble,
Chakraborty, where is he?
my humble submission, my lord, it will be to modify the sentence that is run consecutively instead of concurrently, my lord. Regarding to that, my lord, I have one judgment, my lord. May I
The other side is not there, sir. Anyone for the state? No one. Come back next week.
My lord, tomorrow, my lord.
Tomorrow, I do not know whether it's anyone.
I will inform, my lord. I will inform.
You'll inform, I'll just make it not today. Not today.
Grateful, my lord.
Mm. 148. First file. None appears for the petitioner. No accommodation is sought. The matter be placed before the next available circuit bench. $50.
No, 50, there was direction to effect service upon the state, my lord. That has not been done. If Loshokari takes it up on Thursday, I can complete that.
Since service upon the opposite party is not complete, then let the matter stand over till 2nd May.
Grateful, Lord. I beg of your pardon, your lordship. With regard to item number 33, my lord. My lord, I was in my lord, courtroom number 1, my lord.
your lordship was pleased to post the matter on the next circuit.
Yes.
My lord, but can it be possible, my lord, to take up the matter, my lord, Monday or any other day?
Not to, I'll just make it not today in that case.
My lord, your lordship was pleased to post the matter on the next
I'll
circuit.
make it not today. Come back
Not
tomorrow.
lordship.
33.
No,
33.
33 টা not today বলুন। 33 টা not today বলুন। অভিষেক নিয়েছে বোধহয় বলুন।
But in respect of item number 51, I am appearing on behalf of the petitioner. This is. I am for the petitioner. This is. This is an application for quashing of the criminal proceeding initiated by the Matigara police station in connection.
Aditi Chakraborty is appearing for the state. Where is he? And the case diary was called for.
Yes. There is no stay or interim order.
Yes, yes.
This is an application for quashing the FIR. If your lordship kindly come to page 28.
Have you served the second
Yes,
opposite
yes.
party? Where is your
Yes,
affidavit of
I have.
service?
My lord, yes, affidavit of service with me, my lord. This is the hard bomb, my lord.
Can you file it tomorrow?
My lord, taken a Monday, not tomorrow. Taken a Monday.
Matters are shifting to Monday. Since affidavit of service is not ready, let the matter appear under the same heading on 29th April 2024. Monday, please produce the affidavit of service.
Yes, yes.
Actor line add করুন, case diary be produced on the agenda date. Case diary be produced on the agenda date.
Lordship, kindly take this matter on 30th April. I am for the petitioner. The CD of the CBI is required for place before your lordship for place my case.
Who is appearing for the CBI?
CBI is the petitioner in this case. Your lordship.
Oh.
Cancellation of it.
Cancellation.
When do you want to come back?
Set aside the order.
Set aside the order.
When do you want to come back?
30, your lordship. 30th April.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 30th April 2024. Next. File. None appears for the petitioner. No accommodation is sought. The matter be placed before the next available circuit bench. Same order.
Item 55, Medium matter.
On last occasion, LCR was called for.
LCR is checked. Yes, LCR is there. Who is appearing for the again, Mr. Chakraborty or Mr. Aditi Chakraborty? Yes, Mr. Abhijit Chakra is there. Yes, no one. The CD is also required in this case.
CD is already conviction has been done, so. Yes.
Yes.
He is not required, Your Lordship. Because I have come before your lordship against the conviction.
Please, are you ready today? Because I don't want to make it piecemeal. If you're ready, I'll take up the.
Then lordship, take it up on Monday.
Again, Monday. You are not ready today. Yes.
Lordship, so CD is also required. CD is not required. Already conviction is. The second appeal.
You don't seem to be ready. Come back on the next date. On prayer of the opposite party, the matter is adjourned. Paragraph of the matter appear under the same heading on 30th April, Tuesday. It's a second appeal, isn't it? Anyway, come ready.
57, I only got. 57.
Next circuit.
No, no.
We seriously object.
I'm praying for next circuit.
It's come for Quashing chapter.
I'm not ready, lordship.
There is no stay. Is there a stay or no?
No.
Then what is your difficulty?
How long we want dangling like?
You are not dangling actually, because there is no stay order.
No, my lord, it's some kind of finding of which, whether the weather is favorable or not. Lord, kindly see the number of the cases which was filed in 2023.
It is being shifted to the next circuits for quite some time. Let him come back. On prayer of the petitioner, the matter be placed before the next available circuit bench.
So kindly see how many such cases.
If the petitioner is not interested, and there is no stay also, so you're not suffering. So proceed with the case and let the case be disposed of in the meantime.
All these, yes, money laundering or bond scheme has been transferred to the additional.
I don't have. I don't have any instruction.
You don't have instruction, the notification go to the government, so these things will go there and the matter will be heard by the principal.
Why don't you apply before the relevant court and get the matters transferred to that court? He's shifting the case pending, so he's not interested. There is no bar in your making a prayer in terms of the notification.
But the registered already issued the notification on the bar that this is the situation. Don't file any cases here. Anyway, my lord,
Does the notification have a retrospective effect or a prospective? All that has to be seen. Prospective. So these are pending cases, so it will not apply. If it is prospective, it will not apply then.
Next circuit.
Next circuit.
Next. Because all the matters cannot accumulate next week. All the matters are going to the next week. So that's not possible. Anyway. None appears for the petitioner, no accommodation is sought. The matter will be placed before the next available circuit bench. Same order.
Lordship, I'm playing for not today.
Not today. You'll come back tomorrow? Not today.
Next week.
Next circuit.
No.
On prayer of the petitioner, have you served?
Yes, my lord, sir.
Please inform the state so that I can
Yes.
take up the matter. 482.
Yes.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 2nd May 2024. Next. State. Yes, you're appearing, Mr. Chaudhary. CD was asked to be produced.
Lord, this is a application for praying for quashing of the proceedings. Initially, the case was started under section 448, 323, 427, 506. The petitioner thereafter appeared, was granted bail, and subsequently, on the prayer of the de facto complainant, his second IO has prayed for addition of section 376. But I'll be placing, Lord, before that, Lord, before I go into the Lord, allegations, the petitioner before your lordship is a doctor by profession. He was a trainee doctor at the time of incident at RG Medical College Hospital.
But sorry to interrupt, my lord, just sorry. Thing is that there was a direction to serve the copy to the OP number 2. And that we have already complied through the local police station to the IO. And as per the order,
victim.
My lord, victim. And it stated that then she informed me that now she is residing at New Delhi for her father's treatment as her father suffering from serious leave. So she is unable to come here to receive the copy of the petition, and also informed me that she does not have any local lawyer who will receive it. So this is, she has prayed for time.
But she will not turn up, Lord. I'll explain
That is
why she will not turn.
different, but she is with her father.
But after this, I cannot take up the matter in her absence.
My lord.
She's the victim.
Lord, she is a victim, but
Allegedly a victim.
Lord, may I
According to you.
My lord, why she has described as herself wrongfully. She is not a medical student, and there are many things in this particular case. Why? That is the reason I just wanted to say initially this case was started. May I just brief?
Since she'll be affected,
Like,
I don't
then
think we
I'll
need to
be-
spend time on this today.
Your Lord, in absence.
Will you make a similar effort before the next circuit?
Can it be on first, not so that I can come again and apprise your lordship? Lord?
She has already stated that she is seriously.
Difficulty is, Lord, may I just stop?
Sure.
Lord, the difficulty is petitioner, as I said, Lord, the petitioner before your lordship is a practicing doctor. Lord, dependency of this criminal proceedings, which is absolutely a false allegation. I was not even present in Siliguri. There is a document which says that I was present in RG Hospital on that particular day. That considering that document and on the basis of strength of this submission, I was granted anticipatory bail after adding section 376. I am the person, Lord, who has lodged a complaint, intimated to the investigating officer. See, this is the situation where I was not present in Siliguri on that particular day, including the day of incident. And before 7 days and after 7 days, I was in Calcutta discharging my official duty as a government employee in RG Hospital. They did not bother to look into the document. Despite that, there is a charge sheet. I have challenged the charge sheet on 3 grounds. And why I am pressing before your lordship, because of the reason this pendency of these criminal proceedings is causing hindrance in my future studies. Lord, this is such a case, but palpably a false allegation has been given a color with the influence, I'm sorry to say this, of the investigating agency.
I'm afraid you have to wait till May. Because you are enjoying an interim order which
No,
is
no, I am,
till
but
May.
that's
Please make us another effort to bring her or serve this on her so that.
Not
it
only
can be
that,
taken
my
up.
lord, I will, if my lord pass an order to call for a report regarding the documents which they have filed to substantiate that they were in Kolkata at the relevant time when not in the place of occurrence. So that has to be verified also. Because on the
I
basis of those
beseeching your lordship,
documents-
Lord, to, if in the meantime, Lord, that order is passed, let the
The
investigating officer.
documents are on record.
Lord, yes, I've annexed to the document, obliged, Lord. I'm really grateful to
Because
Mr.
there
Chakraborty,
are
Lord.
originals.
It is starting from page 15, 16, 17, and Lord, 18. I have got this document through an RTI, which would be evident at page 45. Page 45. 43 is the RTI, but the document certificate given by the medical superintendent come vice principal RG Medical College and Hospital is at page 45. Kindly
Please verify all the documents filed by the petitioner in the.
obliged, deeply obliged.
Because in case I mention them and miss out on one, then it will not serve the
But
purpose.
there is another recourse subject to kind sanction. But if the victim is not represented, your lordship, Lord, is aware about the judgment. Lawyers can be appointed through the from the
This is
legal
the
exam.
first date.
No
I don't want to
I
hurry.
let there be another effort. She was a student of dental medical college at Baharampur. Purportedly,
Petitioner may be directed to supply as a copy of the documents. Which
yes, we have annexed, but separately.
That is annexed, but separately the RTI and.
I will. I shall rather supply to Mr. Chakraborty in course of the day. The lordship would kindly pass such order. I thought that I'll be citing few judgments on the unimpeachable document and all this.
No, but this is an interesting issue. I wish I
that
could
will
have dealt with.
that will suffice my purpose and that will strengthen my argument. Obliged.
I was interested in dealing with it. It's very interesting. I mean,
Indeed, Lord.
yes.
That prompted me to come here.
Bad luck. Because at the principal bench, I am not getting this opportunity.
Lord, we are here.
I thought I'll make
See
use
the
of
excitement
your
of my junior, Lord. We really want your lordship to come to the
Chief
criminal.
Justice's prerogative.
We wish, Lord. We
Prerogative of the Honorable Chief Justice. The report submitted by the officer in charge, NBMC, North Bengal Medical College and Hospital, Police Outpost, PS Matigara, is taken on record. It appears from the report that an effort was made to serve the victim, and it was learnt that the victim left her rented house few months back and informed that she is residing in New Delhi for her father's treatment. She has requested for accommodation. Paragraph, the matter be adjourned on such ground. Paragraph. There was a direction through the office of the learned ABP service. The office of the learned APP, additional public prosecutor. Should make further attempt to serve the second opposite party / victim in the meantime. paragraph. The petitioner has annexed several documents to demonstrate that to demonstrate his innocence with regard to the offense alleged. Learned counsel for the said documents be
This was sent to the investigating officer on 12/6/2023 at page 35.
the documents,
Yes,
page 35.
my lord.
Have been sent to the investigating officer with a letter issued on 12th June 2023. Stop. The investigating officer is directed to verify the truth and genuineness of the said documents and submit a report to that effect on the adjourned date. Paragraph learned counsel for the petitioner is requested to serve a copy of the said documents upon learned counsel for the state in course of this day. Paragraph, the matter be placed before the next available circuit bench.
But I have also indicated the permanent address of the opposite party number 2. I have given a copy to my learned friend.
Please try out at that address. It's not that she has not been contacted. She has informed that she's not there. Next.
Lord, the most unfortunate part is, Lord, sometimes police and Lord, the law enforcing agency, other agencies also, they really do not wish to proceed under section 186 or 211. Those Lord, provisions were made to teach or give a lesson. But false allegation is not sustained.
It's hardly used.
No, I have not seen any proceedings. Yet, Lord, after 23 years of my practice, yes. Lord, I'm giving a copy to the Lordship's court officer, Lord, the item 31, the judgment.
Yes. You've referred to two
Yes.
judgments. Put a filer up.
Lord, oblige. But I take your Lordship's report.
Yes, next. File. Petitioners are not interested. This is very unfortunate. Matters keep lingering. None appears for the petitioner, no accommodation is sought. The matter be placed before the next available circuit bench. No use keeping it. I cannot dismiss them for default criminal matters. None appears for the petitioner, no accommodation is sought. The matter be placed before the next available circuit bench. Petitioner?
My lord, I am for the petitioner, my lord.
Yes. Copy not served.
My lord, this victim is residing in Hong Kong, my lord. And we have sent the copy to her previous address, my lord, which was mentioned in the FIR, my lord.
There was a direction for affidavit of service. Have you placed? Yes, please serve learned counsel.
My lord, copy has been given to the
Reconsideration of charge.
This is a very interesting case, my lord. This is a NRI claiming to be scheduled caste. And case was that incident, alleged incident was occurred 22 years back, my lord. And presently she is residing in Hong Kong as an NRI, my lord.
Please serve a copy to her so
I had
that
already
she is
submitted,
ready.
yes.
Next circuit.
Lord.
Yes, because they need to be taken up together, isn't it?
Your Milord
They are connected.
Milord be pleased to order this interim that direction, Milord, to the lower court.
Is there any interim?
No, there's no
order?
interim direction.
And you are not disturbed, so not necessary.
But it is pending.
Next
for the-
circuit starts after a week.
But if your Milord is pleased to consider, Milord.
No, my lord, kindly look at the order of item about 73, my lord. The proceedings have been stalled, my lord. So the importance is the same, my lord. In that case, my lord, Lord Court has, my lord, seen the materials in the case and after that, my lord, the legal period, my lord, till then, only after the hearing of the older petition, my lord, the necessary order will be passed.
Yes, there is a stay of all further proceedings.
Okay, okay.
And it's the same proceeding. The parties are represented. Copy of the application is served upon learned counsel for the second for the second opposite party in court this day. Shall I adjourn it on the prayer of the victim? Since she is not instructed. Shall I adjourn it on your prayer? Since you are not instructed till now, isn't it? You've just received the copy. On prayer of the second opposite party, the matter is adjourned. Paragraph, the matter be placed before the next available circuit bench.
Grateful, Milord.
71, matters be placed. They are together. Action, analysis. Yes.
This is my opinion.
Service complete?
Yes.
The petitioner made a
Who is
complaint.
appearing for the opposite parties?
We are appearing. I am appearing for the state. We are appearing on behalf of the private.
1, 2, and 3. Right. Yes.
The case is, my lord, petitioner is filed a complaint before the learned judicial magistrate Jalpaiguri under section 156(3) of the Code of Criminal Procedure. After filing this complaint, the case was transferred before the learned third court judicial magistrate for disposal. Now, my lord, after inquiry of the police report, the judicial magistrate third court, my lord, dismissed my application. Thereafter, my lord, the petitioner filed a revision of application before the learned district assistant judge, my lord, and the learned district assistant judge, without going through the merit, and also, my lord, without taking view the case is scheduled caste and scheduled type, my lord, without applying the judicial mind, my lord, dismiss the said application. Kindly see, my lord, impugn order and judgment. My first contention is that, my lord, only 2 points, my lord. One point is, my lord, the police did not interrogate the victim. Firstly, not interrogated, not witnesses, the victim. Secondly, my lord, the learned judicial magistrate, where there is a scheduled caste, scheduled type act, but the learned judicial magistrate, it is the duty to transfer the case to the appropriate special court, but did not consider the same and dismiss my complaint. Kindly.
Charge sheet has been submitted?
No. That is complaint case. My
Oh,
lord.
it's a complaint case.
Complaint case. Now, kindly see, my lord, judicial order of the judicial magistrate third court Jalpaiguri on 3rd June 2023.
3rd June.
Yes. That is after certified court, third. After APD.
Yes.
Last second paragraph, my lord.
Last second paragraph. This court
This court
finds
found
that.
the main contestant of the complaint of his essay that the accused used abuse language and harassment them by the as they belong to scheduled caste and scheduled type case. It is found that from the police report that one session case has already been pending on being harassment and complaining by the accused as the daughter of the complaint belong to scheduled caste and scheduled type case. Thus, this case is also on the same matter. My lord, this is not a same, my lord, just cause of action is the difference between.
Have you annexed both the complaints?
Lord, no, I have annexed the main complaint, my lord. Earlier complaint, my lord, that is.
Complaint with regard to this case you have annexed? Because since it is said that they are the same, on the same issue, the earlier complaint also needs to be seen.
Earlier complaint is I have not annexed.
Because the, isn't it? The question is that they are same.
Justify the veracity.
Yes, yes, absolutely.
And secondly, my lord, the police inquired the matter without the examine the victim, my lord, submitted the report.
Will you come back with a copy of the earlier complaint? If this is, if it is a fact that there's an earlier GR case on the Atrocities Act and this is a complaint case, the law is this has to be tagged and dealt with.
But they have the
Cannot be refused, cannot be rejected.
My lord, we have the copies. Apart from it, they have suppressed the material facts of what the self-same issue a civil suit is pending. It is the central principle of law that no one trying to impart criminal color to a civil dispute is impermissible. Apart from that, filing of petition under section 156 subclause 3 of the CRPC before the Chief Judicial Magistrate of Jalpaiguri bypassing or by way of erasing the scene of the special code, whether permissible or not. This is the main issue. Since, my lord, section 41 of the IPC, section 1 of the 41 of the IPC dealt with the special act, particularly said under what circumstances special act or special statute to be enacted. And so far the section 20 of the civil caste and civil type atrocity here, it is amply clear that it has the overriding effect over all other general statutes. And they have filed an undated supporting affidavit with the Chief Judicial Magistrate Jalpaiguri. Rather, when they have the opportunity to file the same application before the special court. Now the question, whether the filing of petition before the Chief Judicial Magistrate, other than the special court, when the matter involving the issue of civil considered atrocity is permissible or not, that should be considered as possible. This is the main crux. That apart, they have suppressed the fact that civil suit is pending. And that
please come back with the relevant documents.
We have got all the references.
The learned court directed to police to investigate the matter, but the police did not investigate the matter properly, my lord.
No, learned counsel is challenging the maintainability itself. Strikes at the root.
Yes.
Isn't it? If it is not maintainable before the Chief Judicial Magistrate, nothing could have been done. If it is under the Atrocities Act.
It is the duty to the Chief Judicial to transfer the said complaint before the affidavit.
No, not at all.
Why could you not have filed the application before the special
Before the
court?
appropriate bench.
153 is permitted on its Chief Judicial Magistrate.
No, absolutely not. Can you allow me? Can you allow me? One.
The word magistrate does not exclude the magistrate within the definition of the special judge. Magistrate also include the judge or magistrate presiding in the special court. Any magistrate does not mean.
But one thing, madam. In certified copies, my lord, order dated 10th of October 2023, my lord. After the magistrate's order, my lord. After 2-3 pages. Judgment of
9th October.
Session Judge, additional district and session judge, Hard Court, Jalpaiguri.
Yes.
Got the lord, kindly come to page 3. Sorry, my lord, page 4, my lord.
Yes.
At the very outset, outset.
Yes.
Kindly read that portion.
Yes. That's the law.
That's the law. It is very much clear.
In a revisional application.
Yes. Then, my lord, it should be dismissed without wasting the valuable time of the court, your lordship. This is a settled law, your lordship.
And the court has held that there is a procedure contemplated for.
Right,
under the
absolutely,
under the
absolutely right,
Special Act.
absolutely right.
Yes, special act. But my lord, kindly see the 156(3) below.
That proposition has already been dealt with by the learned session judge while entertaining your revisional application.
Absolutely.
Right, duty to the learned judicial magistrate to transfer the case to the.
No. You have to file before the appropriate court of law.
Come back with the relevant documents. Let me find out. Let me see.
Mongol. Soombar, দেখা যাবে না।
When will you come back?
But Tuesday, next Tuesday.
Matter is very simple and hinges only in one point. We are striking the root of this case.
30th April.
30th.
Why not with the leave of you, we have to the vocal.
In the department. Affidavit of service. Heard learned counsels for the parties. Let the matter appear under the same heading for further consideration on 30th April. 2022.
Grateful, grateful, grateful.
None appears for the petitioner. No accommodation is sought. The matter be placed before the next available circuit bench.
One more indulgence in respect of the item number 74. The matter has fixed on the Thursday, but make it order or hearing should be conducted on maintainability point. On the point.
Formula act line add করুন, the issue of maintainability is kept open.
76, my lord, and for the petitioner, my lord, it is, my lord, for extension of interim order. CRAN is also, my lord, lying with the revisional application, my lord.
CRAN 1 of 2020.
CRAN 1, my lord, yes, my lord.
Not disposed of.
No, my lord.
Have you served?
Yes, my lord. Service has been effected, my lord.
There is, you on the earlier occasion, you sought time to serve. Where is your service?
My lord, affidavit in service is not ready, my lord.
Can you come back tomorrow with your affidavit?
Yes, my lord.
The service is complete?
Complete, my lord.
On all the opposite parties?
Including the, my lord, the complainants.
Yes, the state and the other opposite
Yes,
parties.
yes, other opposite parties.
There are 7 + 1, 8 opposite
Yes, my lord. They have been served by my lord, postal service.
And it is all delivered to them? You have
Yes,
all the
delivered, my lord, delivered.
You have all the track reports?
Yes, my lord.
Will you come back with an affidavit tomorrow?
Tomorrow, my lord.
So not today only?
Tomorrow.
Not today?
Yes.
Yes.
Case under section 612 of POCSO Act, read with section 66E, 67B of the Information Technology Act. I have agreed by an order dated 12/2/2024, and the order has been annexed at the end of my application, my lord. My lord, in this case, my lord, an application was filed by the accused person as because he was prejudiced by the trial. Why, my lord? As because the charge sheet was submitted, my lord. I would like to draw your lordship attention to the charge sheet first, my lord.
The petitioner is the accused before the trial court?
Yes, my lord.
It's at the evidence stage.
Yes, trial is going on. At page number 21. It's a charge sheet, a continuation of the charge sheet.
Is part of the application. These next, then there are the orders.
21.
No, these are all copies of orders. Where is the charge sheet?
I think some, oh, I think it is in the envelope. It has been enveloped.
In the envelope?
Envelope. And because of POXO, rape case.
Yes. Live streaming off. Kuru.